Now is 11:40. Let's resume. So let's move to agenda item 20, regulatory update. Mr. Mark Johnson, please.
Thank you, Amy. Okay, board members. This is our usual regulatory. It's in the usual format. However, you will notice that we have put in rulemaking package to be reviewed by the board at a future meeting, public meeting, to determine status. What that means is that we are intending in the next couple of months, probably, hopefully before the August meeting, to sit down with legal counsel and review all of our existing board-approved regulations. These are regulations that have been approved by the board at previous meetings, but have not been publicly noticed or published for public review. What we want to do is just to basically determine the viability of certain regulations. If the board wants us to continue with the packages, or perhaps to roll them into another one or something along those lines, or even to abandon those. The idea of this is just that because we've had much higher priority regulatory packages in the last couple of years that we've had to implement, that we haven't really had the time to work on these. And a number of these regulations were kind of put into, they were probably not really vetted enough with the board. So we want to try to get kind of a little more clarity on what we want to do with that. And again, this is something that we've been kind of looking at for a little while, that we need to kind of move on some of these regulations, and this way the board can determine which ones we want to move forward with and which ones perhaps we want to not look at anymore. So that said, we do continue to kind of discuss internally at a staff level some of the different regulations and how we can implement them and whatnot. So it's an ongoing process, but it's sort of a process we want to take a look at again. Okay.
Any questions from the board members?
I don't.
Thank you, Ruben.
Not for me at this time.
Thank you, John. Joe? Okay.
Public comment on this item? Oh, not seen, not hearing. Okay. Let's move to item 21.
Okay. Thank you, Amy. Okay, board members. This is a discussion that we want to have on some various items, some legislative bills of interest, possible interest to the board. The way that we, first off, the way that we have kind of come up with this list is that our legislative review section from the Department of Consumer Affairs keeps a very, very comprehensive list of bills that may apply to different departments or agencies within DCA. And in reviewing with them and our legislative contact over there, and then with Ben, we've sort of narrowed down bills that we think would be of much greater interest to the board. And certainly if there are bills outside of what we've listed here that the board wants us to look at, or we get feedback, we can certainly do that. We can look at those as well. But it's just a short list of bills that we should be looking at. A couple of notes about legislative deadlines, and these are very important to keep in mind as we move forward. The legislature has in their rules certain deadlines that have to be met with legislative bills. Bills, for example, with any fiscal impact have to be passed out of their policy committee by June 29th. Well, obviously that is today. Okay. Bills without a fiscal impact, and just about all the bills that we would look at require a fiscal impact because they have some sort of state mandated legislative program. They have some sort of effect that would require monies to be dispersed, whatever. So almost every bill that we're going to be looking at has a fiscal impact. A bill that does not have a fiscal impact needs to be passed out of a policy committee by July 6th, which is next Friday. Okay. it's another important thing to remember here that the legislature, as of July 6th, will be on recess for 1 month. Okay, so nothing happens. Basically, if the budget bill is passed, which it has been and was signed into law by the governor earlier this week, they can adjourn by July 6th, which it's my understanding they're intending to do. Then they return from legislation on return to legislative affairs on August 6th. The next deadline is that any fiscal bills, again, these are bills with a fiscal impact, must be passed out of the fiscal committee, i.e. appropriations, by August 17th. Okay? And then the last day for the legislature pass bills is August 31st, right around midnight. That's when the legislative session ends, the action's over, and then the governor has until the 30th of September to sign any bills that the legislature has passed. Okay, any questions on timeline? Good, okay. What we did is, in this memo, we've set out a short, just sort of overview of the bill itself, what it does, staff comments on the bill, and generally, I know some of you are familiar with this process, but others may not be. Generally, you want to take there's about 5 general positions you want to take. Obviously, a support position means you support the bill as it is and thinks it become law. Support if amended. I know one of our public comments was mentioned that they had a supportive amended position on a bill. You know, that means that the bill would, the board would support the bill becoming law, but feels that amendments would be necessary for it to become law. There is a straight opposed position, which means obviously the bill should not become law. The board does not feel it should become law. Oppose unless amended. The board can conditionally oppose the bill and feels amendments would be necessary to remove the board's opposition to it becoming law. And then the 5th one is just a watch or a neutral position, which is basically, you know, the board will just have staff watch the bill for any further impact. The first 4 positions that are taken, we would inform the legislature via a letter, generally signed by the executive officer, informing the author of the board's position. That letter is also sent to the relevant policy committee. So if a bill, it goes to business and professions, if it goes to appropriations or is in that stage along the process, the letter would go to that committee. And then it's usually just a smart idea to always CC the minority side, i.e. the Republicans, about the opposition to a bill as well. And it's generally not necessary to inform the legislature about a watch position. You know, if the board wants to do that, we certainly can, but it's generally not needed. Okay? Okay. Any questions so far?
I don't.
Okay. Our first bill, oh, and just by way of note, we do have the most recent version of the bill. This packet did go to press. I want to say early last week. So some of the statuses have been updated, but it should be the very latest version of the bill in the packet, along with the most recent legislative analysis. But I'll give kind of updates on the various statuses. The first bill is Assembly Bill 767, having to do with the Master License Business Act. This is currently, it did pass out of the Senate Business and Professions Committee. It is currently in the Senate Appropriations Committee. This bill would create an online internet platform called the California Business Development Portal that would allow sort of a one-stop shopping for potential licensees, businesses, if they wanted to kind of form a business in California, and would also create what's called the Master Business License Center, which would establish an online permit assistance center. This bill is still a little bit in flux. We're not sure if it would. One of the things that it would essentially require is for boards to participate in this Master Business License Center, and so there's been a lot of concern about how our board would interface into that system. A lot of other boards have this concern. And it's a little unclear if the bill would mandate our board participating in there. So anyway, it's not been determined how it would sort of affect our processes. It's not been determined how it would affect a lot of different things. So it's a recommended watch position. That's our staff recommendation.
I recommend that board take a position after each piece if they want to take a position, just so we don't have to go back at the end.
Good idea. Okay. Ron?
No, I personally agree with the staff recommendation just to watch, not take a formal position. But that's where I stand on it.
Okay.
Can we hear a motion for the watch position?
I would move to take a watch position on Assembly Bill 767.
I second.
May I suggest that a motion also give authority to the executive officer to, well, for motions where there's actually a position other than watch support, there should be a motion, include in the motion authority the executive officer to, pursue actions to support or oppose the bill.
There's a suggested motion at the bottom of page 1, which the board may choose to take if it wants.
Yes, that's a good template.
Public comment?
Do we need to do public comment after each one or after the motion, or can we do it at the very end?
I think there should be public comment after the first and second.
Seeing and hearing no public comment, can we take roll call vote?
Okay. The motion is by Harabedian to watch AB 767. Second is by Mateki. The vote, Mateki,
Yes.
Chan,
Yeah.
Harabedian,
Yes.
Osorio.
Yes.
4-0, motion passes. Thank you. Okay. Okay, thank you. B, Assembly Bill 1659. This has to do with healing arts boards and inactive licenses. This bill has had no opposition throughout the process. It is currently on the Senate floor on the consent calendar, which means that, again, that there's no active opposition to it, and it's likely just going to sail through, and the governor, there's a very good chance the governor will probably sign it. This bill would just authorize a healing arts board like the Acupuncture Board to establish a lower inactive license renewal fee, and also would prohibit any licensee who is on inactive status from representing that they are on an active status. Sounds a little, kind of procedural, but that's exactly what it would do. It's it would have no real impact on us. It would create an additional violation for disciplinary action. Another little tool in our enforcement toolbox, which is never a bad thing. And staff recommends a support position on this one.
I'll make a motion. So I motion that the Acupuncture Board will take the support position on the bill 1659, Healing Arts Board's inactive license.
Okay.
And direct the EO to inform the legislature and the author's office of this position.
I'll second.
Public comment? Seeing and hearing none, roll call. Vote, please.
Okay. The motion is by Dr. Mateki to support AB 1659 of the board's support and direct the EO to inform the legislature. The second is by Harabedian. The vote, Mateki,
Yes.
Chan,
Yes.
Harabedian,
Yes.
Sario.
Yes.
4-0, motion carries. Okay, the third bill, AB 2138. This is, I'm going to start by saying this is a very complicated bill. There have been a number of meetings about it. Staff, Ben has been going to a number of the stakeholder meetings. I've been participating. It's a very it's a fairly complicated bill, and it's difficult to get your head around. But we tried to kind of boil it down to the most important points. It has to do with licensing boards, denial of application for licensure, revocation or suspension, and the role of criminal convictions. Currently, this bill is in Senate Appropriations. It was double referred to the Business and Professions and Economic Development Committee, which it passed out of there on a 6-3 vote. That was 6 Democrats in favor, 3 Republicans not in favor, and then it also passed out of the Senate Public Safety Committee on the 26th on a 4-2 party line vote as well. And so the bill is now moving to Senate Appropriations. I think probably maybe the basic thing to do is perhaps just read the description of the bill to get a basic flavor. Because like I mentioned, this is a very complicated bill. It would do a lot of different things. Anyway, so current law requires a board to develop criteria to aid when considering the denial, suspension, and revocation of a license to determine whether a crime is substantially related to the qualifications, functions, or duties of the business or profession the board regulates, and requires the board to develop criteria to evaluate the rehabilitation of a person when considering the denial, suspension, or revocation of a license. So this bill would revise and recast those provisions and instead authorize a board to, among other things, deny, revoke, or suspend a license on the grounds that the applicant or licensee has been convicted of a crime only if the applicant or licensee is presently incarcerated or the conviction as defined occurred within the preceding 7 years, except for serious felonies, and would require the crime to be substantially related to the qualifications, functions, or duties of the business and profession. The bill would also prohibit a board from denying a license based on the conviction of a crime or the basis or of acts underlying a conviction for a crime if the conviction has been dismissed or expunged, if the person has provided evidence of rehabilitation, if a person has been granted clemency or a pardon, or if an arrest resulted in a disposition other than a conviction. The bill would also require the board to develop criteria for determining when a crime is substantially related to the qualifications, functions, and duties of the business and profession, and would prohibit a board from denying a license based solely on an applicant's failure to disclose a fact that would not have been cause for denial of the license had the fact been disclosed. The bill would also make other conforming and process changes. So, confused yet? Basically, my comments, and I have been talking, and I know Ben has been talking to other boards, other executive officers, and other staff about the impacts. But the concerns that we have set out right now at present. The first concern was obviously the board would be prohibited from denying, revoking, or suspending a license on the grounds that an applicant had been convicted of a crime unless the conviction had occurred in the last 7 years and had not been expunged. The crime must be substantially related to the qualifications, duties, functions of the profession, etc. It kind of ties the board's hands, and I'm looking at Christine just because she works in enforcement and can probably advise on this a little bit more, but that prohibition kind of ties the board's hands a little bit with the type of actions that we can look at when we're looking at a license. Now, it's important. I think it's also kind of important to keep in mind that this bill would not apply to a lot of people, at least within our board. I think we've had 1 or 2 people that the provisions of part of this might be applicable to in the last 2 years, if that 1 or 2 people. So it's against it would, at least in our board, it would be in a very small, it's a very, very tiny amount of people that this would apply to.
I do want to add that we have a small population, like 1 or 2, that we actually get to the point where we want to deny a license, but the population of people that we look at for having criminal histories, that's larger, and they would also be affected because they we're not allowed to require them to disclose things about their criminal history. So that is a large impact.
And that was actually kind of the next one, and this is a little bit more important. The board would lose the ability to thoroughly review a licensee or an applicant's criminal history, since the bill prohibits the board from requiring a licensee or an applicant to disclose their criminal history. Now, what that means in practicality, as I understand it, is that we would basically no longer be able to have a question that says, have you been convicted of any crimes, or have you been convicted? The only way we'd really be able to determine that is via the live scan process.
And that's beyond 7 years from the date of application.
Yeah.
So we can only look as far back as 7 years.
My understanding, I think, is that it just narrows the types of convictions that the board can ask about, right? So I think my understanding is, for example, fraud or
But, yeah.
items that aren't in the category of, I think, maybe violent
Yeah,
felonies as
violent,
opposed
serious
to
felonies.
Yeah.
Yeah.
So-
Originally, the language had only referred to violent felonies, but now it refers to serious felonies, which there is a little more broad description of what a serious felony is.
So I think some of the concern there is that crimes that the board would be interested in knowing about
Mhm, we wouldn't
because
be able to
they
ask about.
affect, they're related to unprofessional conduct, substantially related to the work of licensees,
Mhm.
and might harm the public if it's not captured, would fall through the cracks should this bill go through, and the board would no longer be able to collect that information as,
That's a, yeah,
as being one of the major, I think, flaws that a lot of, I think, the boards, healing arts boards, are taking issue with right now.
that's great. That's absolutely correct. That's great insight. Thank you. So there's that concern, which I find is a major one. The third concern that staff has is just that we would lose the flexibility to impose certain probationary options on applicants who have committed certain crimes. That kind of goes with the point that Sawa just made. And I mean, again, with our small board, this is no small concern. Board workload would certainly increase due to legal reviews, process changes, and additional new data reporting requirements. We did indicate, and our budget analyst agreed, or when we did do a fiscal review of AB 2138, that this would not have an impact on our board. But it's a little tough to gauge that, and our feeling is that it probably would have, especially once it gets into law, the actual impact it would be a law, we'd have to reckon with it. And certainly this bill would spawn a number of different regulatory changes we would make. That's all workload, obviously. Fifth, there are numerous potential conflicts with existing board laws and regulations, which, like I mentioned, will require revision and potential statutory changes. Anyway, so this bill appears to be largely aimed, the author's office has said that this bill is largely aimed at different professions, such as, contractors or Board of Behavioral, or Board of Cosmetology and Barbering and Cosmetology. It's aimed at potential licensees who may have a greater likelihood for some sort of criminal issues in their background, but it obviously would apply to, because it would apply to all boards. It'd be universal. So everybody from medical doctors, dentists, acupuncturists on down, or across. So the general feeling is that this bill does not really fit into our mandate, which is, as we all know, to protect the public. So we are recommending an opposed position on this. A number of other boards, Behavioral Sciences, Medical Board, Pharmacy Board, have all taken opposed positions on this bill. So,
Any questions from the board members? This is a lot to digest, and this bill has actually changed form several times. Initially, it was for 5 years. Now it's for 7. You can't look back further than 7.
It was originally quite draconian, and there was there was obviously a tremendous outcry from the boards that did not support this. The other thing that it does do that I forgot to mention is that it would limit probationary terms to 2 years. 2 years.
That is for convictions prior to entering
Yeah.
into the field.
Yeah.
No, the
So, sorry, go ahead, Madam Chair.
well, the part I just want to see, even we are a small board, we have a small numbers, maybe get an impact. But even you have a one, and the part is the impact for the public. They goes to seeing patients. So regardless, we are small board, small numbers, but I really have a problem with how do we protect the public.
Thank you. Thanks, Mark, for the report on this and the other bills too. Very thorough. The one question I had was, the bill was originally going to change the standard to directly and adversely related, but it's actually back to substantially, which is good. But I guess a related question is just how do we currently define substantially related? I know whether this passes or not, it's going to still be substantially related, I would think. I would think that the bill doesn't change that, correct?
That's already in place.
Okay, so on that piece, I guess, whether it passes or not, that's ultimately a good thing for us. But
My understanding, the bill wants us to develop a criteria or guidelines to set what would be substantially related, whereas now we don't have something in place. It's looked at case by case, and we always contact applicants to provide evidence of rehabilitation, all of the information about the incident for us to be able to review to make that decision about whether or not it's substantially related and cause for concern for the public.
It removes some of the board's discretion.
yeah, I'll just make a quick comment then if we're taking comments now. Yeah, I agree that we should oppose this, for the mere fact that it does take away our discretion. And I think that ultimately that makes it harder for us to protect the public and actually address licensees that, or potential licensees that need to either have their license revoked or not be given a license in the first place. So to me, I think that the authors of this bill, I think, are trying to come from a good place. If you read the reports, they're trying to make sure that recidivism and those who have been convicted of crimes are able to re-enter the job market. And I totally agree with that. Totally agree with that. With that goal, I think, though, that when you're talking about re-entering a profession such as, the medical field and specifically, the acupuncture field, I mean, you have to weigh that goal with the health and the safety of those receiving services. And I think that is ultimately what drives this board. So I think because of that, we have to be very careful of making it harder on us to make sure that those who have a license to practice acupuncture, are being dealt with correctly. So because of that, I agree with staff's recommendation. Make a formal motion on that. I'll move that the board adopt a oppose stance on AB 2138 by authors Chu and Lowe, and direct the executive officer to make that position known to the legislature and the author's office of this position.
Second.
May I make a recommendation that there be some clarity in the motion about what it means to inform the legislature? Like, for example, and I might defer to the executive officer about what kind of authority you might be looking for, like, for example, to draft a letter on behalf of the board, or
That would be the extent, yeah.
Yeah, with that, so amended, with that to my motion. So
A second.
A public comment? Seeing and hearing none. Roll call, please.
Okay, the motion is by Harabedian to oppose Assembly Bill 2138 and to direct the executive officer to inform the legislature of this position. The second is by Dr. Matecki. The vote, Matecki,
Yes.
Jan,
Yes.
Harabedian,
Yes.
Masario.
Yes.
4, motion carries.
Thank you.
Thank you. Okay. The fourth bill is Assembly Bill 3142. This is the board's sunset bill. This would extend our board operations from January 1st, 2019 to January 1st, 2021. It is a 2-year extension, not a 4-year extension. Originally, we were slated for a 4-year extension as the board, as the bill language was introduced. However, when it went through the committee process, it was shortened to 2 years. The bill does a couple of various things. It just clarifies the terms candidacy and pre-accreditation to match ACOM's language, clarifies the use of titles and responsibilities. It deletes an outdated and inconsistent reference to the number of clinical training hours, and also clarifies that, consistent with our policies, the board should consult with all of the necessary healing arts boards for the development of infection control guidelines, which is something that we do, but it's a lot of this stuff in the bill is just essentially kind of clarifying and cleaning up. And then it also clarifies that the licensee must hang a wall license in each practice location, not have a pocket license, which again is just kind of a clarification thing. Obviously, it is a 2-year extension. It's not a 4-year extension, but aside from that, it does not propose any other major changes. So again, we obviously want to support this bill. So.
If there's questions from the board members.
Like a comment?
Oh, we didn't have a motion though.
Was there any discussion
So I
or
will move.
any questions?
I have a comment, but do you want a motion first, or should we make comments? Okay, yeah, I mean, obviously support the bill, but I think that the public comments earlier and some of the issues that we brought up on the enforcement side, and obviously I think those apply to all the operations of the staff and our board. 4 years would have been better, and for various reasons, but this is my personal opinion. I know staff is recommending the support of the 2-year, and I think that the legislature, has their reasons, and I think this could have turned out much worse, right? I mean, they could have done a lot of different things. So so I'm in full support, obviously, of the bill. I think that hopefully the next time that this comes around, we've proven that we deserve a 4-year. So to the extent that there are any questions left, hopefully over the next 2 years, the legislature clearly defines what those issues are and gives us a chance to address them in a full-throated way. So I'll make the motion. Or actually, I'm going to defer. I've made too many motions, so I'll make it. I'll just wait.
No, if we oppose, what can we get? We asked for 4 years. They give us 2. If you oppose this bill, so it's still getting 2, right?
Opposing would mean you don't want to be sun-risen at all, or an extension date.
Yeah.
And then,
Do we get 2 years or we don't get any?
They'll probably do whatever they want.
yeah.
So
Kidman, let me just say, I do not recommend an opposed position.
And even oppose unless amended or support unless amended, those are also tricky when it deals with our own reincarnation.
I make a motion to support this Assembly Bill 3142. And if the EU can have some kind of description to
Send a letter.
or do whatever to comply and support this bill.
I second that.
Public comments on this?
Michael Fox. I am so happy that you guys have been working hard over these last few years, and I must say I am disappointed that we still haven't gotten a 4-year renewal. Is it clear to you and to everyone exactly what needs to be done next time to get the 4-year renewal? Or because we've never seen the checklist, is it absolutely clear what has to get done? Because I know in our unification efforts, it's pretty clear. So I'm hoping you guys have that clarity as well. Thank you.
Thank you. Any other public comments? Seeing no, hearing no.
Okay, the motion is by Kipman Chan to support AB 3142 and direct the Executive Office to inform the legislature of this position. Second is by Ruben Osario. The vote, Mateki,
Yes.
Chan,
Yes.
Arbedian,
Yes.
Osario.
Yes.
4-0, motion passes. Okay, last bill is Senate Bill 1448. This bill is currently in the Assembly Appropriations Committee.
Sorry, Mark. Before we go, can I just ask a question? And Ms. Bojack, correct? Stop me if I shouldn't ask this. But can I ask just to address that question? Is that?
Yes, you can
okay.
address the question.
Yeah, I think it's a good question. I mean, do you as a staff think you have that checklist of things that need to be done so that we get the 4-year?
Yes, we've been working diligently on addressing unresolved matters. And to me, the checklist is exactly what was discussed in the previous background papers. And we've done some rather diligent effort to address all those issues, going so far as to receive compliments or at least acknowledgement from both the committees that we have been improving, as well as from our stakeholders. Now, what does it take to get from 2 to 4 isn't as clear. I think it's just persistence in this kind of diligence. So we really do hope that if we continue as we have in 2 years, it will be a clear 4 renewal, so to speak.
Okay. Okay, last bill, Senate Bill 1448. This bill is this.
Point of order, can we acknowledge that we're crossing 762 out?
Oh, I'm sorry. I completely skipped that. I'm sorry. Okay, Senate Bill 762. This bill originally had to deal with license activation fee and a waiver if a licensee was going to perform nonprofit service and whatnot. The amendments dated June 11th now have the bill subject to a completely different subject, not of interest to the board. So it was put on, it was changed after we agendized it. So anyway, yes, thank you, Ben. Okay, Senate Bill 1448. This has to deal with healing arts licensees on probation status. What this basically would require is that it would require acupuncturists to notify patients of their probationary status in terms of that they would have to notify each patient that they are on probation and what the probation is for. And probationers would be required to have a signed copy from their patient that, I have noted that my practitioner is on probation, et cetera, et cetera. This bill is it's been around for a couple of years. It's never passed. A number of physician groups and other practitioners are opposed to the bill. It would have kind of a minor impact on our operations, but a potential impact on our licensees, obviously. But this is a protect the public bill, so it's it's a little bit of a tricky situation for us. Right now, under our current disciplinary guidelines under the probation monitor, we can require licensees to notify their patients that they are on probation. It's part of one of our disciplinary guidelines, one of our terms, and it's a go.
Okay.
Yeah.
It's under the practice monitor
Oh,
condition.
okay.
And they're just required to notify patients that they have a practice monitor. I don't think it's actually required that they state that they're on probation, just that they'll have access to their records. The practice monitor will have access to their patient
okay.
records. Yeah.
All right, I was wrong.
That's okay.
So anyway, so it's kind of something that's something we already do, but this would obviously make it mandatory for all licensees who are on probation to notify their patients. We recommend a watch position on this one.
I want to add that we also, in our disciplinary guidelines, require that they probationers have to notify like their employers or supervisors that they're on probation, but they don't have to put like a notice, or anything like that for the general public.
Any questions or comments from the members?
When you say watch that, why? When you say watch, how do we wait for the outcome of the bill amended or?
Yeah, I mean, board staff would continue to observe what happens if there was something that was sort of a little more drastic, which made the bill worse or whatever. We would inform the board and take a position at that appropriate time. Again, we are getting kind of close to some deadlines, so there's a fairly good chance it's not going to change much, but you never know. Anything can happen.
No further questions from the board members?
I want to clarify, I think just to go to Kitman's question is the purpose of maybe taking a watch position as opposed to not taking any position at all, is it kind of directs staff to keep an eye on it. So it just communicates, I would say, to the legislature and to staff that this is something that's of interest to the board, though not necessarily of such concern to take either a strong position of support or oppose. It's just that, hey, we're interested in this. It might evolve into something that might, warrant taking a support or oppose position in the future. So, the position essentially directs staff to keep an eye on it.
Looks like a promotion. We have to motion.
But I have a question. The way I understand, why can we take what would be better for us to take a position on it rather than being neutral? Isn't this on the benefit of the public?
Well, again, this is one of those bills that it's kind of tough because such a probationary notice would, that would kind of protect the public. It would require all licensees, but it also would have an impact on the same licensees, so that would be required to do it. I mean, the simple argument against that is, well, don't violate any regulations or laws. But, again, I mean, it's kind of up to the board if we want to stay neutral on this position, on this board, on this bill, so.
What is the other board currently, like medical board, pharmacy board?
Uh,
Do they same way
I-
like
you
us,
know,
like a watch?
If you give me a minute, I can quickly find out. I know that I believe that a number of like physician groups and such are in opposition to this. But in terms of what the boards are doing, boards themselves, I don't know. Let me one
Stay
sec.
with the
My anecdotal talks, or my anecdotal reference to this is in my talks with some of the other boards, they weren't too supportive of it. Now, any official positions I'm not familiar with.
Yeah.
It just makes it more challenging for the licensee. Now, this would increase public protection in terms of notification, right? And we did note that currently we have approximately 36 licensees that would have to broadcast this, or at least sign the declaration, have their patients sign the declaration. So there is a public protection element to it. The question is, does this go too far? I think that's some of the concerns that these other professional associations are having. And I'm not sure if any of the professional associations here have any position on that they'd like to discuss.
The other thing to point out is it's Business and Professions Code Section 27, I believe, already requires that all boards, basically all of DCA has to post the disciplinary action of each licensee. So if somebody from the public were to search for their license, even sometimes search for their name on Google, it will pop up with the disciplinary action. They will see that they're on probation. So we do have that out there. Just wanted to point that out.
Right now, there's no registered this is as of June 16th. According to the committee analysis, there's no registered opposition, which means no boards have officially taken opposed positions. The registered support is Consumers Union, Consumer Watchdog, Consumer Attorneys for California, Center for Public Interest Law, etc.
I think, the watch position probably is, good for the board.
Okay.
A motion for that?
Since the here day is not set, so I think the boss should, my personal think that we should take a watch, because you never know after the hearing day and the outcome might be affect our either support or oppose position. So I'd like to make a motion to take a position on watch on the Senate Bill 144A, and of course, if the EO have the discretion to compile the law and do whatever necessary.
You, Kipman, do we have a second?
Did you want more discussion?
I guess I second that.
Public comment? Any associations have any position on this matter? Seeing and hearing none, can we take roll call?
Vote. Okay, the motion is by Kipman Chan to just watch SB 1448 and for the executive officer to monitor developments. The second is by Sario. The vote, Mateki,
Yes.
Chan,
Yes.
Harvedian,
Yes.
Yes.
Sario.
Yes.
Our motion carries. And that's it for my legislative report. If any other, any members have any other bills that we want to keep an eye on or anything like that? Okay, thank you, members.
Any public comments? Seeing no, hearing no. Okay.
Okay.
So I know we went through a lot, and thank you, Mr. Johnson. Thank you, board members. So we will break for lunch and reconvene in the afternoon. We have two more big items, strategic planning and also discussion about the disciplinary guidelines. It's currently 12:28, so we will resume at 1 o'clock. Is everyone okay? Half an hour break for a quick lunch? Or you want a 1 hour? Half an hour? Okay, I know many of us will travel, so half an hour break. Thank you so much for your participation and support.
Thank you. We'll see you at 1. Thank you.
Oh, yeah, it's 1:16 p.m. Okay, let's start with item 22. Discussion and a possible board action on 2018 to 2021 Acupuncture Board Strategic Planning. Mr. Boudia, please.
Thank you, Dr. Mateki. For the strategic plan, the board has done a great amount of work, working with as well Solid, the department's strategic organizational leadership and individual development office, to work on its new strategic plan. And this, what you see, is the draft copy of all that work, including a number of surveys to stakeholders, board members, staff, as well as 2 sessions of strategic planning where the board members as well as the stakeholders were together in developing the board's next 4-year plan. And what I'll do is I'll take it page by page, and any comments from the board, please go ahead and jump in once I've finished the review on that page. I'll start with page 1, the title page. It shows the strategic plan from 2018 to 2022. The consideration was, do we want a 5-year plan or a 4-year plan? And currently it's listed as 5 years with 2022.
4 years? You said 5 years?
With 2022 as the 18, 19, 20, 2022?
It depends on how you count, I guess.
Right. So we can either just be clear that this is a 5-year plan or leave it at that. Are board members okay with this being a 5-year plan? Okay, so we'll leave this as a 5-year plan, 2022. I'm sorry? Yeah, okay. On page 2 was just a listing of our current board members as well as the executive leadership for the state, the department, agency, department, and the board. Any questions there or amendments?
I think we'll just, the footnote that says 18 to 2021, we'll just want to change it to 22.
Good catch, thank you, sir.
Started what? 20?
The footnote,
The bottom.
the footer shows to 2021. We want it to reflect 2022. Okay, on page 3 we have the table of contents. It's pretty straightforward. Any items there?
Same thing that I put down the change to the 2022 every page.
Okay, we'll have that as a universal edit for the rest of the document. Page 3 is a location where the board president and the board executive officer can write a letter of introduction and welcome if desired. In the interest of time, we did not have these drafts ready for this meeting, but the board president and myself can provide this at a later date. Page 5, about the acupuncture board, brief description. Any questions or comments there? Seeing none. Our mission, vision, and values, these were newly selected with this last strategic plan. I'll go ahead and read those just so we can get that out. The mission is to protect the people of California by upholding acupuncture practice standards through the oversight and enforcement of the Acupuncture Licensure Act. Our vision is the exemplary practice of acupuncture for the health and safety of the people of California. And our values are consumer protection, first and foremost, collaboration, excellence, integrity, and professionalism. All right. So for page 7, we have the strategic goal areas. These are the 6 areas that we will be working on to improve the board and also continue the board's work. We'll go ahead to page 8 and start with goal 1, licensing. The purpose of licensing is establishes and maintains licensing requirements that protect consumers through improving standards in licensing examination, continuing education, and access to the profession. We have 4 goals here. First, 1.1, develop and implement the computerized licensing examination to increase access and facilitate entry in the profession. 1.2, adopt regulations requiring a passing test of English as a foreign language, or TOEFL, score for international applicants to enhance communication with the healthcare industry and the public. I'm sorry, I added the public, so just the healthcare industry. 1.3, research the feasibility of establishing a clinical inspection program to educate licensees and promote compliance with the laws and regulations relating to the practice of acupuncture. And finally, 1.4, improve pocket license material quality to reduce fraudulent activity. Were there any questions, comments, or concerns on this goal area?
Is it the 1.3 is protect the acupuncture in California? Should we add that in California?
We can. Would that specificity assist us in
It's
this
everything
location?
is for California.
Ultimately,
Yeah.
authority is only for California, but we can be more clear.
Yeah.
I mean, it would add clarity.
It would add clarity.
I don't think it's, you know.
Required, but-
Required, that's a good way to put it. It's not required, but it would add clarity.
There's a clarification here. Can I come up?
We wait for the public comment?
It's up to the president.
Yeah, how about,
Because
doing
no,
the
it's
first
it's
goal area,
just
so we
what
can-
you
Okay,
went
we
over
come-
that.
Yeah.
okay, so
Yes.
then please.
Yeah, so a clarification as far as the TOEFL score for foreign applicants. These are foreign applicants. I would say that it would be very specific to be prescriptive for non-English speaking. In other words, if they come from Canada, they're going to have to do this, or England.
I can see.
So that is, you know, are you going to have somebody from Oxford University take a TOEFL score, or from Canada, or from New Zealand, or from Australia, or from Singapore? So those are really important because, you know, I know that most of our college students in America couldn't pass those TOEFL score. It's really tough. And, you know, if they're English-speaking applicants, what if they have finished an English-speaking university in English, and they have maybe even a master in English or from an English-accredited speaking university in the United States or any of the English-speaking country? I think it is being a little bit unfair. And if they have the educational background and they have finished a 4-year or a 2-year master's degree in an English-speaking country that has an accredited university program, I don't know if this is the best way to go. And I know that ACOM has been putting this into effect, and we just had an issue where somebody's come from England, and you know they finished a top university in England. Should they be taking a TOEFL test because they're a foreign applicant? So maybe for non-English speaking country, or if they have not done an English education. Just an idea. Thank you.
Thank you.
Speaking to this is for one of the 3 qualification routes to the examination itself. So the intention here, and we can definitely clarify it if the board feels there's a requirement, is for anybody that's using that 3rd route. Now, being that you went, let's say, to a school in England doesn't necessarily mean you have a mastery of English per se. If there's other accommodations, I mean, Canada has French universities as well. So it's easier, I think, in terms of when looking outside of the United States, that a TOEFL will be required of those applicants. It's specifically for people taking the exam in the test not in English. So we can clarify like that for those applicants taking the test not in English. The board be amenable to that?
Yes. Yes.
Tammy?
I just wanted to make a clarification that there's not actually a passing score per se on the TOEFL. So the board could establish an acceptable score that's maybe lower than what BPPE or ACOM would require, just for, you know, the ability to converse with other healthcare practitioners.
We would need to be careful to not establish lower standards for foreign applicants than domestic applicants. So equivalency would be best. So, and then in terms of the language for that, adopt regulations requiring a passing test of English as a foreign language. Or for applicants taking the exam in a language other than English.
That works.
To enhance communication with the healthcare industry. Did we want to also include the public in that? And the public? Is that necessary? No? Okay. So we have amendments to 1.2 and 1.3.
So is the 1.3 amendment the addition of California?
That is my note so far.
So just a point on that, I imagine that there could also be federal laws that relate to the practice of acupuncture. Perhaps one way to word it is compliance with the laws and regulations governing the practice of acupuncture in California.
Governing.
That way, you know, it doesn't limit it in a way that's, you know, too narrow.
So governing the practice of acupuncture in California. Any further questions on that? Did we want to refine the language for the passing test? We used passing test here because both BPPE and ACOM have TOEFL standards. And we can talk about equivalency with BPPE or ACOM.
I think a consistency would be better,
Okay.
right?
In my view, is we can keep it in
As is.
to Tammy's point, and then obviously when we're adopting regulations and
Make that a
to
point.
this, then we can tackle that specific issue and figure it out.
Okay. So we can leave it as is.
Makes sense.
Okay. All right. Any other public comment for the goal area 1? Seeing none, we'll go to goal area 2. This is on page 9 of the strategic plan. This is enforcement. The goal of this is to protect the health and safety of consumers through the enforcement of the laws and regulations governing the practice of acupuncture. We have 5 goal areas here, 2.1 being develop and implement the continuing education provider audit process to increase compliance. 2.2, recruit additional subject matter experts to meet the needs of the examination, enforcement, and education units to increase enforcement resources. 2.3, research the feasibility of requiring licensees to maintain medical records in English to facilitate enforcement efforts and increase accessibility. 2.4, update disciplinary guidelines to preserve consistency, fairness, and ensure effective consumer protection when taking disciplinary actions against licensees. 2.5, promulgate uniform standard regulations on substance abuse to safeguard the health and safety of licensees and consumers. Any questions, comments from the board? Staff? The public comment? Seeing none, we'll move to goal area 3, page 10. Education. Advance education standards to increase the quality of education and ensure consumer protection. We have 4 goal areas here, 3.1 being research transfer credit policies and procedures to ensure competent education outcomes, as we even heard in public comment today. 3.2, conduct a cost analysis on training program curriculum application reviews to properly allocate costs and ensure training program compliance. 3.3, review current curriculum standards to ensure it prepares licensees for entry-level practice and consumer safety. And 3.4, define what constitutes live continuing education courses to ensure that hands-on training for continuing education in treatment methods is received in the proper setting with the appropriate supervision to practice on the public. Questions or comments from the board? Staff? Public comment? All right, we'll move on to goal area 4, legislation and regulation. The board advocates for statutes and adopts regulations, policies, and procedures that strengthen and support its mandate, mission, and vision. We have 6 goal areas here. 4.1 starting. Recommend legislation relating to the number of times an applicant can take the examination for licensure to reduce fraud and enhance qualification of licensees. 4.2. Investigate the feasibility of site inspection authority of licensees to increase enforcement resources and access. 4.3. Seek citation authority over curriculum violations of training programs to enforce curriculum requirements established in regulation. 4.4. Review and update regulations to align with statutory requirements. 4.5. Research the feasibility of amending Business and Profession Code 4935 to coincide with General Business and Professions Code to change from misdemeanor to felony to establish deterrent to protect the public. 4.6. Implement a continuing education course and monitoring fee structure to allocate the cost of the process to the continuing education provider applicant. Questions or comments from the board? Okay. Staff? Public comment? Seeing and hearing none, we'll move on to Goal 5, Outreach. Board educates consumers, licensees, and stakeholders about the practice and regulation of the acupuncture profession. We have four goals here. Number 1, develop and implement a communication plan to inform the public about the practice and regulation of the acupuncture profession. 5.2, develop and release a digital newsletter to inform and educate the public. Number 3, determine and communicate licensing reciprocity to and from California to convey California standards to the public and ensure consumer protection. And number 4, update and publish an informational brochure to educate the public on the standards of practice. Question or comments from the board? Seeing none, we'll move to staff.
For 5.2,
Mhm.
does the board want to consider adding what the newsletter is going to inform the public about?
How about adding on acupuncture practice in California? Would that be clear for the board?
Adding as items as such as violations or that type of
Specificity?
yeah.
I think, Salvo, you're just saying to just really make it more about acupuncture as opposed to...
Perhaps some, I mean, it just doesn't indicate, it says develop and release a digital newsletter to inform and educate the public. Would that be maybe, just some guidance, like inform and educate the public about, updates to the rules and regulations relating to the practice of acupuncture, or, updates about what's happening with the board, or, just what one might expect to see in a newsletter issued by the board?
Probably a good idea just to kind of keep it somewhat
General, and
yeah,
then
keep it general, but a good newsletter would have all the things we've discussed. I mean, violations, statutory updates, etc. So,
but we should still direct it to acupuncture. Right now,
Yeah.
Ultimately, it says we can talk about anything.
Yeah.
So perhaps then educate the public on the practice of acupuncture in California, unless board members have greater specificity they'd like.
I think then you will narrow down. I like the update, so maybe we can put a word there, just
On updates to the practice of acupuncture?
because they're related practice.
Hmm?
It's a brain.
I mean, I guess in reading 5.2 with the introductory clause, which is the board educates consumers, licensees, and stakeholders about the practice and regulation of the acupuncture profession.
Mm-hmm.
If anything, I would just probably put educate the public, regarding acupuncture profession. I would just keep it pretty
General.
I want to make sure you folks in doing the newsletter can have like as much flexibility as possible. And then if, to the chair's point, maybe can put the word updates or newest developments. Is that what you're getting at, Madam Chair? Like developments in the acupuncture profession? Is that what you're?
Yeah, it's like the update, what's happening in the profession.
So why don't you just say to inform, educate, and update the public?
Public.
The public, on the acupuncture profession or practice.
I like the profession, maybe.
To inform, update, and educate the public?
Yeah.
And then was there something after that? Or were you okay
Yeah.
with the preamble being that it's already targeting
I think, it doesn't hurt just to say on the acupuncture profession.
profession? Okay.
Yeah, it's
Profession. Okay, I'll read that back. Develop and release a digital newsletter to inform, update, and educate the public on the acupuncture profession.
That's good.
Any other questions or comments from the board? Staff? Public comment on Goal 5, outreach? Seeing and hearing none, we'll move on to Goal 6. Goal 6 is board administration. The board continues to build and maintain an excellent organization through the development of staff, responsible management, strong leadership, and effective board governance. We have 5 goal areas here. 1, conduct a yearly workload study to ensure adequate staffing levels. 2, map the board's business processes to procure an internet technology system that addresses the board's functions. 3, conduct a fee study at appropriate time to address the board's budgetary structural imbalance. 4, respond to Department of Consumer Affairs routine internal audit to address any findings. 5, expand targeted training and materials for board members to educate on governance and the subject matter of the board. Any questions or comments from the board? Can, I think, in 6.2, to procure an internet technology system, I think it's information technology system was the original intent. So IT solution. Is the board open to that?
Yeah, that makes more sense.
All right, that one change now reads, map the board's business processes to procure an information technology system that addresses the board's function. Any further comments from the board? Staff? Public comment? Please. No, step up to the mic.
Mention the updated newsletter, and that's very good idea. So I want to confirm: will you send email to everybody, or just on your board website? So I think if everybody get informed, we avoid a lot of lawsuit. I said a lot of lawsuit cases. They don't know. And until something happened, they say, oh my gosh, I did this. So I think that very, very important to educate acupuncturists and educate the public. So if possible, email I think is good. But a lot of people, they don't get on the board's website. The email will be, everybody get it, if possible. Thank you.
This would be going back to goal 5. I believe the goal is relatively general enough to allow for either email or web posting, but it's something that we can take on to make sure that it is emailed once it's being developed. Board members, okay? Yes. Yeah. Going back to goal 6, any other public comment? Okay. Page 14 of the document is just the process that the board used to develop this plan. Any questions, comments there? Seeing none from the board? Staff? Public comment? Okay, and then our last page, just basic contact information.
And
yes?
at the bottom, it also doesn't have 2018 to 2022.
Ah, good catch.
Yeah.
Thank you, Christine. So noted. And that is it. If the board is okay with this, we would entertain a motion to approve the strategic plan and direct staff to implement it.
Well, I think with the incomplete page 4, not having substantive material, including the message from the EO, possibly a message from the board president, I might recommend holding off on a motion until that substantive material is added.
We were informed that this was optional to do this. Would we be able to bring back text at a later meeting to include with this strategic plan and approve this as is with no comments there?
So would it be approved with page 4 deleted? Because if you approve it as is, then as is, it says please insert a message.
I'm open to taking this page out.
No.
No.
Which page is that?
This would be page 4 of the document.
I'm fine with that.
You hear that?
Yeah.
Okay, so we'll remove page 4 for now. And then should Amy and I write that, we'll bring that before the board.
Okay. Yes, that's fine. I'll make a motion.
Make a motion
Okay.
that we approve the strategic planning
With the changes made?
with the changes that have made, yes.
Okay.
You have a second?
Okay.
And I would recommend that the motion, as usual with things that are going to be posted on the website, authorize the executive officer to make technical, non-substantive changes that are necessary.
Ruben, are you okay with that amendment?
Yes.
Okay.
Public comment?
You just read the motion
Oh.
back?
Osario motions to approve the strategic plan with the changes made here today and delegate to the EO the authority to make non-substantive changes. The second is by Chan.
Thank you. Is there any public comment? Seeing and hearing none, let's go to roll call.
Okay. Motion is as stated. Mateki,
Yes.
Chan,
Yes.
Harbedian,
Yes.
Sario.
Yes.
4-0 motion carries.
Thank you, members. This will be our plan for the next 5 years.
Thank you. So now let's move to agenda item 23. Discussion and possible board action on proposed Acupuncture 2018 update to disciplinary guidelines and the implementation of uniform standards related to the substance abusing licensees. Christine Brother and Mark Johnson, please.
Thank you, Madam Chair. Okay, board members. This is a proposed update to our existing disciplinary guidelines, which have been in place since 1996. And originally, when we had agendized this item, we had intended to include 3 items that the board was going to review. The first was going to be the actual text to amend the regulation in 1399.469. That text would have included changes to the actual language itself. Because we have not, we are still kind of reviewing the changes that we ultimately want to make to the guidelines and the uniform standards, which I'll get into in a second. We opted not to bring the text before the board right now. The intention today is to just simply review the disciplinary guidelines themselves. And the uniform standards related to substance abusing licensees was going to be the third thing that we are going to have the board review. However, we have not finalized those yet and are still discussing the best way to implement those. So today the intention is just mainly to give the board an opportunity and the public an opportunity to review the proposed changes that we've offered to the guidelines themselves. And kind of that'll be our first step, and then the hope is to bring back the guidelines again with potentially the uniform standards at the next board meeting if we can do that. So anyway, just is kind of a brief background on what we've done. We have these guidelines are used by the board, by ALJs, et cetera, involved, anyone involved in the disciplinary process. Ben?
For the public, ALJ is administrative law judge.
We've been using the same one since 1996. Our current guidelines are outdated. There's been multiple changes to the laws and regulations since then and modifications to discipline standards. We've been working on this one way or another for many years. Most recently, the board had approved revised guidelines and text last year at the February 24th, 2017 meeting. After that, we had, the Attorney General's office had actually, we had asked them to review our guidelines, because they're the ones that are kind of the folks on the ground who have to utilize these when doing any kind of work. We wanted them to take a good review at it, and they did. They suggested a number of changes, which we've integrated in there. And so we're now going to be discussing some of those changes as well. Just a short background on the uniform standards for substance abusing licensees. I don't know, Ben, Amy, if I need to discuss this because it's not really relevant today. Since we're not discussing the uniform standards document, do we still want to kind of go over that real quickly, or?
It's on the agenda, so if you
Okay.
would like to discuss it.
I mean, I'd say we can go ahead and start with the disciplinary guidelines first, and then we can address that once we get to the end of this and kind of preempt what we'll be discussing next time.
Sounds good. Okay, so if you turn to page 4 of this memo, what we've done is we've set out just kind of a page by page or a condition by condition review of what has been done. It occurred to me it probably would have been handy to have the actual disciplinary guidelines marked up separately so you don't have to do so much flipping back and forth. But if you look at the document itself, which is right here, it's behind the orange page, you'll see the disciplinary guidelines themselves. Now, the way that this is set out is that anything that is just normal text with a strike through, you'll see existing text is just existing text. There's no underlines, there's no strike through, no nothing. That's existing text in the 1996 guidelines, okay? So the first change that we've made from the February 24th, 2017 meeting is that text is underlined. So that'll indicate new text that's going into these disciplinary guidelines. And then existing text from the 1996 guidelines that is being removed is struck through. Okay? So now, for the purposes of our board meeting today, text that has been added since the board approved the February 24th version of the guidelines has been added. That is double underlined, okay? And then if anything that we decided we want removed, that'll be double strike through, okay? Does that make sense, members? Okay. So what we've done is for the purposes of the memo, we just noted here that V1, which is version 1, which is the version that the board approved last year in February, the changes that are set out, that was done as part of version 1 that the board had already approved. But because we have new board members, we want to sort of reacquaint everybody with the changes that we're proposing and the board had largely approved last year. And then version 2 is, again, the versions that we are proposing now in consultation with our attorney generals, with our legal counsel, and with staff changes as well. Okay, any questions on the formatting, anything like that, members? Okay.
So I was just going to go through the memo where it sets it out page by page with the guidelines. So if you have questions on each page, I'll just kind of pause and so with the introduction, which is on pages 4 and 5, in version 1, the introduction has been expanded to explain the purpose of the guidelines and identifies who the interested parties are to enhance clarity. New language has been added that sets out the different categories of probation terms and conditions. Version 2, which would be after the last year's meeting, added a reference to the Uniform Standards Regulation to carry through authority. Do you guys have any questions on those 2 pages?
And just as a quick aside, in consideration of length, we try to edit down the memo as such as possible. But the original memo was close to 20 pages long. We tried to reduce maybe a little bit about the impact or the reasoning for the changes. But a lot of it was just, again, like I said earlier, changes in law, changes in how our board, the day-to-day practice of it, things like that. And the benefits are most importantly to protect the public. That's kind of the chief benefit of having better guidelines, is to protect the public. But it's also another benefit is for more clarity for licensees who are on probation to understand, more clarity for those involved in the disciplinary process, et cetera, et cetera. So anyway, sorry, Christine.
Oh, no. Yeah, so we didn't really go into length with the changes that we did to version 1 because the board had already kind of reviewed that. So if you want to sort of target the emphasis on the double underline and the double strike through, then you'll see the changes since the last time they were reviewed. But by all means, please ask questions on, version 1 changes as well. So for the general considerations on page 6, a new proposed section, this is a new proposed section with a list of general considerations to help users determine whether revocation, suspension, or probation is to be imposed in a given case, with a list of factors to be considered. Version 2 adds items 8 and 9 to provide for the board's review of respondents' acceptance of responsibility of their actions and respondents' honesty during the proceedings. Questions? Move on to the terms and conditions on page 7. In version 1, a third condition category was added to set out special conditions that require a specific penalty. Version 2 adds a reference to section 1399.469, subsection B, which would be the uniform standards regulation. The special conditions that we're proposing are, sorry, I got off here. Yeah, the special conditions are addressing like the uniform standards. And then,
Sorry, Mark and Christine, just really quickly, can you just, when we say uniform standards, before when Mark was talking about it, he was, I believe, talking about the uniform standards as to substance abuse licensees. When you use is that the same, when you say uniform standards, are you referring to the same thing?
Yes.
Okay.
Yeah, so they kind of all tie together. This is a little bit confusing because we were going to have separate documents. We're going to have disciplinary guidelines separately from the uniform standards, but they could also be combined. So that's another thing that needs to be determined because they do kind of, work together. So you'll see references to uniform standards for an administrative law judge or a deputy attorney general and looking at the disciplinary guidelines. It's for the general licensee population who's violated the laws and regulations. The uniform standards would be used for if they violated anything related to, they're determined to be a substance abusing licensee. So
Is there reasons to have, standalone standards for that subpopulation?
it's mandated by the legislature, yep. All the healing arts boards have to use them.
And we'll touch on that once we reviewed. We've discussed the guidelines. We'll kind of touch on the uniform standards a little bit and explain the history of that and all that.
So what you're seeing here on page 7, subsections A and B, is mirrors what the proposed text was originally kind of drafted to look like. So this language here is in flux, and it's going to change based on whether the board ultimately approves a combined disciplinary guidelines and uniform standards package versus separate documents. This version of the text indicates the uniform standards as a separate document under subsection A.
So I'll move on to, we can get on into the actual terms and conditions that we're proposing for the disciplinary guidelines. So a lot of them are, ones that we already have in place in the 1996 with some changes. And then we've actually added some new ones by looking at different boards, seeing what would be helpful to our probationers and to our probation program. So let's see. Did I leave off? Okay. So we didn't have any changes to the first condition, which is actual suspension. Oh, yeah. No, I am. Yeah, no changes to the actual suspension. Then we go right into number 2, psychological evaluation on page 8. In version 1, language was added to provide authority that allows the board to require a respondent to comply with psychotherapy if deemed necessary by the evaluator to be paid by respondent. In version 2, we added a reference to the most current diagnostic and statistical manual of mental disorders, DSM-5, to be used during the evaluation. Also in version 2, the note was amended to require an additional term, number 15, supervised practice, be added to the disciplinary order if the evaluator finds the need. Additionally, a second note further clarified that therapists shall have the correct knowledge and experience in the area involving a violation. I was going to point out that we just actually, we weren't adding that supervised practice be added in version 2. We just identified that it wasn't the following term for clarity. We actually identified the term that should be included and called it out. The note, the board requires that therapists have appropriate knowledge, training, and experience in the area involved in the violation, just strengthens it.
Notice that we're adding 5, which would be psychotherapy. And they seem to overlap, and I assume someone not trained in medicine, there's a really good distinction why you'd have both.
Right.
But it's not clear to me why we would have the psychological evaluation and the psychotherapy. So I guess, again, I'm sure there's a good reason for it. I just don't.
Well, we added it. They can either run concurrently, or it could be a standalone. Let's see. I think the psych eval, we would order that there's the actual evaluation piece of it, whereas the psychotherapy, we've ordered that they do ongoing therapy. And both the so in number 2, psychological evaluation, they can get an evaluation conducted by a psychologist, and then they can recommend to the board that there be additional therapy or psychotherapy that goes on. So they are very similar, but if you want to ensure that the probationer has the ongoing psychotherapy, you would put the term in the decision in order.
I'm sorry, go ahead.
Let me just add it. So the evaluation is like an initial assessment. So, and then can determine, so psychotherapy is determined the treatment, is a possibility, maybe refer for further psychiatric, so other. But the initial, this is the evaluation, just kind of assessment.
So from the psychological evaluation first, and then go to the psychotherapy. And after the evaluation determine the person go to the psychotherapy.
It's like the treatment plan, so.
Correct.
That's correct, right?
Yeah.
Okay, so.
You could use them independent of each other as well and not have a psychological evaluation. If
Just helpful to have the evaluation first.
It is, but we've had actual times in the past where they've already been under the care of a psychotherapist, and we want to ensure that that carries on. So then we would just put in place the psychotherapy term. So it's just more flexibility to have the two. Let me know if you want me to not read verbatim, each item. If you want to just review it, we can go page by page. I can just call it the page number, and if you guys have any questions.
Hey, yeah, that's fine with me. I don't think I need you to read everything. So.
Okay, that's fine. So we were
Members,
on
are you
page
okay with that?
9.
Yes.
Okay. Please.
We can move on to page 10. This is the practice billing monitor.
Yeah, so can you just, I guess, the 2-minute overview, like what is changing here? I understand I could read through this text and kind of decide, but the practice monitor wasn't billing.
Yeah, we didn't
okay.
have it set up to where we could also have a billing monitor. So it adds that in. I believe it also added, I have to reacquaint myself. I think it provided that we would actually identify the monitoring plan, whereas before they would send in their monitoring plan and then we would approve it. So we're actually the ones, the probation monitor, enforcement staff would be the one to say what the actual plan would be, or excuse me, the executive officer would be. Those were two big changes.
It's going to be the same person every time. We wouldn't assign a practice and a separate billing monitor, right?
So they actually have to find a licensed, another licensed acupuncturist to serve as their practice or billing monitor. So they find whoever, then they send us the qualifications for us to review. They can't have any prior relationship with them. And then they would set up, if they're going to get paid, that's all done between the probationer and the monitor. So we don't find the actual monitor. They could have somebody who serves as both practice and billing, if they have the right qualifications for that. Sometimes we may just institute that it be a practice monitor versus both, or just a billing monitor, like if it was like a fraud case, or both. Yeah, let's move to, okay, so I'll move on to 5. Psychotherapy was actually on page 11.
So sorry to go back. I
Yeah.
think one thing, and what I took a while looking for is where it is like psychological evaluation, where it says a board-appointed California licensed psychologist on page 8 identifies who's going to be doing the evaluation. And I think, when I was originally going over it, I noticed some back and forth either in this section or the psychotherapy section,
Yeah.
where the terminology just kind of changes, whether
Yeah.
it's a therapist or a psychologist or a
Psychotherapist.
Yeah, I saw it going back and forth.
Yeah.
And, I'm not an expert in the field, and, you guys know this better than anyone, but just some clarity on exactly who is supposed to be performing these things, and just kind of consistency in that terminology.
Okay.
Would the psychological evaluation, would we want that done by a psychologist, an actual licensed psychologist or psychiatrist, whereas, or would just somebody who has a master's in therapy be sufficient to do that evaluation?
So here for the psychological evaluation, we say a California licensed psychologist. So we do identify, and for the psychotherapy, we identified it by saying a California licensed mental health professional who has been approved by the board. So it kind of leaves it open to where it'd be anyone qualified to do psychotherapy, to practice psychotherapy. I don't know if the board wants to identify specific license types who would be allowed to do the psychotherapy. This is on page 11. Psychotherapy.
But as it stands right now for part 2, section 2, psychological evaluation, it has to be done by a psychologist the way we're doing it.
Yeah.
Psychiatrists can't conduct this.
That is accurate, yeah.
Is that commonplace? Are psychiatrists not able to do such evaluations?
No, I mean, we can allow for it to be that. I mean, they would be paying probably more money for a psychiatrist, but if the board wants to do that and allow it for, either one.
Well, just, as a medical profession, just in generally, if they are trained, psychiatrists definitely do the psychiatric evaluation, and primary care physicians. So I think, they can choose psychologist But then we eliminated other professions, right? What if a psychologist is not available? They can just go to, you know,
The mental-
physicians, a psychiatrist.
Yeah, so we could open it up, we could list more if you guys.
I mean, the
Okay.
text that is down there that says appointed California licensed psychologist, again, the unmodified text, that's the text we've been using since 1996, with a licensed psychologist as the person able to do the evaluation. So, that is something we can change if the board wants.
I mean, why don't we just use the same language that we have in the proposed psychotherapy, which is just a California licensed mental health professional?
Yep, that's, I was gonna suggest
That's
that.
good.
That's-
Mental health profession.
Covers both.
Yeah.
Yes.
And for number 2,
Correct.
Right,
the,
Page 8.
for number 2.
leave
Or
it
send-
also open for number 2?
Yeah.
Right.
Mental health profession, so that would give a bigger.
So on page 8, under number 2, line 4 would say, by a board-appointed California licensed mental health professional, period. Okay? Does that work for the board?
Do we want them to be appointed or approved by the board?
Ooh. Question.
I would recommend leaving it more specific for the psychological evaluation. Generally, I think what I've seen in other guidelines, it is more specific for this term of probation, especially, the following, that they're going to apply the, DSM on mental disorders, and it's really just more specific. So I think perhaps saying something like any psychologist or psychiatrist is what I've seen. It also might call for just surveying kind of what other guidelines look like in this area for some guidance, but
Yeah,
it's just, that's my recommendation and what I've generally seen.
How does the board feel about that?
I mean, that sounds fine to me. Because, the physical, to Ben's point, the physical exam is approved by the board, and then the psychotherapy is approved, but then here we'll be appointing. So I'm just gonna have to defer, I guess. In my mind, what Sawa said makes sense to me, but if you guys, if staff thinks one is better than the other, happy to hear it.
I think, Sawa, you were talking about it just not being more broad, and that it just narrowing it to either psychotherapist or excuse me,
Appointed.
yeah,
Psychologist.
psychologist or psychiatrist.
So
But
I
she-
wasn't speaking to the appointed.
Yeah, she wasn't
She
speaking
wasn't.
to that.
Then
Yeah.
then in my opinion, it should be approved, not appoint.
Let
But
me
I thought that she
can
was
I
speaking to. Yeah.
let me speak to the appointed. Most boards do have a list of approved psychologists that we've already kind of reviewed and deemed qualified to do psychological evaluations. So we'll give them a list, by their location. That way they can't just be open to choose anyone to do their psychological evaluation. We already have an approved list, and they have to go from that list. That's how we currently do it, and that's how I know a lot of boards do it. That's why it says appointed, I believe.
I think appointed is kind of confusing in that sense then, like the board would have to appoint someone at an official meeting that these people are
Oh.
approved.
I think it should be
They are
approved.
appointed, because approved is just the board accepts them.
Okay, yeah. It might be just,
numbers?
yes, it's older
Yes.
1996 language, so.
Yes.
Language changes. That would be line 4, section 2.
Okay.
By a board-approved California licensed mental health professional.
I believe Saul was also speaking to the specificity. Do the board members want to also include, instead of licensed mental health professional, a licensed psychologist or psychiatrist to address Salva's specificity?
So, I mean, yeah, so I guess the question is, where did we get this language for psychotherapy? I assume we took that directly from another agency or board. So, if they're using this broader California licensed mental health professional, do we know if that's the medical board, the chiropractic board, do we?
I actually think it might have been the medical board. I had to I had to Google psychotherapy to see if it identified specific license types that can do it. It's just anybody who can practice, psychology and, who can do ongoing therapy.
For the public.
Well, I think we've determined. And so, instead of just a general medical doctor, a psychiatrist who is a medical doctor but specializes in psychiatry to perform a psychological evaluation, something more than just like a 5150 hold, which is an emergency.
You need
Okay.
more than just psychologist. Yes.
So then, what I'm hearing is that we can change, instead of just psychologist, it'll be a board-approved California licensed psychologist or psychiatrist, just for the psychological evaluation section.
And we will provide a list, right?
We will
Yeah.
have an approved list, yes. We will add or psychiatrist.
That we restricted from practicing on. And added that they have 60 days from the effective date to submit a plan to implement the restriction. Any questions? Page 13. Number 7, restrictions on practice techniques and modalities. So this identifies different treatment modalities they would be prohibited from providing. Before, I think we had phrased it in a way where they would be limited. We were identifying practices they could do, and that would be too exhaustive, so we changed it up this way. And then also adding that they would have to notify present and future employers of these restrictions imposed on their practice.
While on probation.
While on probation.
Would that specificity help here?
Oh. They're on probation. It's only, right?
Sorry, 7.
Sorry.
Restrictions on practice techniques and modalities.
Oh, since it says future employers?
It says future employers there, so I
Couldn't
want
hurt,
to make
yeah.
sure that don't feel compelled to do so after they've completed probation.
We want to add that in, so it would then read, respondent shall notify all present and future employers of the restrictions imposed on their practice while on probation. Okay.
Board members, is that specificity okay?
Yes.
Okay.
We already had the examinations term. We just amended it. We don't know what types of licensing exams we're going to have, so we left it broad. We no longer have a clinical portion of the exam, so that was taken out. And we do identify that if they have not passed the examination within 15 months, then it would be a violation of probation, and we would petition to revoke their probation.
Any questions there?
Okay. Number 9, restitution on page 13, going on to 14. Really not many changes there. So I'll go on to term and condition 10, alcohol and drug abuse treatment program.
Can I stop you for a second there,
yeah.
Christine? Just since we have new board members, what you see at the top of page 14 is us crossing out AC, and the original disciplinary guidelines referred to we were the acupuncture committee at the time under the medical board, and so that's why you see the AC crossed out there. And we've changed all AC references to board references.
Right.
Thank you.
We added that we, in the alcohol and drug abuse treatment program, that we would accept a recovery program taken under court order within the last 3 years. And that they just need to submit proof of completion. We took a lot of language out.
And that was dealing with the 12-step programs, as there was group therapy programs that worked outside of just the 12 steps.
I guess, can I ask a question about accepting a recovery program taken under court order within the last 3 years? So I guess I'm a little confused by that, because if we decide that they need treatment, and they need some sort of alcohol or drug abuse program, then we go and say, but we'll accept anything that you've done in the last 3 years prior to the effective date, then we're basically saying, like, you don't need treatment. You've already had it, you know? So I just, to me, I don't know why we would include that. It's either they need it and you need to go get it, or you had it and now we don't think you need it. So
Right, so we don't put the term
I just don't
in.
think that should go in there unless I'm missing, in practical application, this has come up and we've been, oh shucks, we can't accept that prior recovery program that you were in.
We have added it in, like, in our stipulated settlements. It'll sometimes be negotiated in because we're implementing discipline soon after a DUI or something like that, and they are having to complete that usually sometimes within the last year or two. And so they just completed it, and it's the same basis for action. So we will accept that recovery program, which will be equivalent. It's like the same thing that we would require. So that's why it's come up, and that's why we probably put it in, because it's been implemented in decisions previously.
Yeah, maybe, I guess within the last 3 years, it's a long time.
Yeah.
So maybe like a year, or.
Okay.
Board members, what kind of, John has suggested 1 year,
Reduce it to 1 year?
so that we can only accept what has been completed in the last year.
I would agree, yes.
Yep. Kevin?
And in version 2, we just added a reference to the note that we're retaining some terms that relate to substance abuse, I guess, or just substance use. But if the licensee is deemed to be a substance abusing licensee, they have to go under the uniform standards. And so we just added a little clause here saying that that would be what they need to be under in the probationary order.
You're referencing the note, the double underlined
Double underlined
portion.
note, yes.
So for that note, at the very end of it, it says it shall be used in any probationary order of the board affecting that licensee. I would recommend that it indicate in lieu of this term and condition.
That would be good.
In lieu of any probationary order? Is that
In
what
lieu
you-
of this condition.
Okay.
Or condition 10.
Yeah, so if the probationer is determined to be a substance abusing licensee, then instead of using term and condition number 10, the probationer would be facing the uniform standards, those terms and conditions.
Members, are we okay with that?
Yes.
Okay. Thank you.
So we may want to add that because I think we put it in term 11 and 12 in the notes. May want to add that same in lieu of this condition.
Condition. Okay. Keep that in mind as we approach those other
Okay.
conditions.
So the reimbursement for probation surveillance monitoring, that just got crossed out. It's no longer a special condition. We moved it to a standard condition to be included on all orders, so we'll get to that. Number 11, attend chemical dependency support and recovery groups. So as you see previously, we had the 12-step meetings as part of the treatment program. It made sense to do away with that and have its own standalone term to address that. And that's what that's doing there.
And then we have the note there. So at the very end of that note, we can add in lieu of condition 11. If the board members are open to that. Okay, that shall be added.
So,
Change, so you can go
yeah,
off of that.
condition 12, abstain from drugs and alcohol and submit to tests and samples. So as pointed out in version 1, marijuana got added in and then we took it out due to the legalization of marijuana for medicinal purposes. So if somebody were to have an actual prescription for marijuana, this would allow, if it's a lawful prescription, part of a documented medical treatment, then that would not be a violation of this term. And let's see, what else did we do?
Shouldn't that be with the prescription?
Yes, it would be
Yeah,
with the
okay.
prescription, yeah. So we rewrote it for better clarity, and we referenced updated, the reference was updated, and an exception was added allowing respondent the use of prescription drugs, as I said. And a reference to the board's uniform standards was added. So,
And that would be another in lieu of
Yeah.
change.
and at the end
global
of the
change.
note, yeah, we would want to add the same in lieu of condition 12. And just to also give an overview, so in the uniform standards, the frequency to have somebody test, do a biological fluid test, is identified like between, I think it's like 52 times a year to 104 times a year in the first year, and so on for each subsequent year. Whereas, and that's if they're a substance abusing licensee. If they're not deemed to be a substance abusing licensee, we would have more discretion on the frequency, and that's why we're retaining this term here. In an example, like if it was a minor DUI or something like that, they might not be deemed to be a substance abusing licensee necessarily, but we might want to monitor them and do some biological fluid testing. So moving to term 13, coursework. There were some changes there. It used to be that they had to do 20 or 30 semester or quarter units of coursework at a graduate level school. It was very excessive. And usually we'll recommend, ethics or other areas to where schools don't even really offer that many units. So they'd be like retaking courses, and we made it open to where the board staff would designate the course content and the number of hours appropriate by the violation. 14, community service. We didn't have actual language to put into a probationary order in our 1996 guidelines. So for that, and it would allow probationers to do community service that's either professional in nature or non-professional.
Why, on the top of page 17, is there a reason why we're taking out the failure to complete the community services set out as grounds for filing a petition to revoke probation?
That was a staff call, just given the fact that we have a violation of probation term that basically states if there's any violation of any of these terms, it's deemed a violation of probation. So it sort of felt redundant. You could put it in, though. It could go either way.
That makes sense.
Okay. 15, supervised practice. This was kind of put in, previously we would use like third-party chaperones to address sexual misconduct cases. We felt this was better because it's actual supervised practice. They have to have supervision while they practice. So this is, have to have face-to-face supervision. Has to be a licensed acupuncturist with a clear and active license. Let's see.
Yeah, and not to go back, but now I'm going back to the practice billing monitor on page 10.
Huh?
I don't think we specify that the practice or billing monitor needs to be California licensed acupuncturist, but I think we do want to specify that, right? Wouldn't a monitor only be a licensed acupuncturist?
Yeah.
Unless it's in there and I
does
missed
say
it.
the name and qualifications of one or more licensed acupuncturists. Yeah.
It is in there? Okay,
It's in there,
got it.
yeah.
Can you point it out for the record, please,
Yeah, I
Blair?
got it.
Oh, sure.
Line number 4,
it's-
right?
Yes.
Okay.
Line number
Okay.
4.
Do we
Page
want
10.
do we want to specify California there, just to be totally clear, like that they can't bring in someone from Montana? Yeah.
That would be good.
Yeah,
That's
we could definitely do that.
Try to go back.
No, that's good.
Yeah.
Please.
Yeah, because they need to, obviously know our laws and regulations,
It says California acupuncturist.
standards, yeah.
California license.
So the change is on line 4, more California licensed acupuncturists.
Okay. So, I don't know if there was any questions on the supervised practice.
No.
Brand new term, yeah.
Then here we should add the California also.
Yeah, the California's in there, yeah.
Okay. So also on line 4, only under the supervision and direct observation of a California licensed acupuncturist.
Perfect.
Say it later, California, so that's
Oh, do we?
start of the second paragraph.
Do we only want a California
do.
licensed acupuncturist to be a supervised practice? I mean, what if an MD wants to do it?
Let me read on. I thought we did allow hold on.
MD may
Yeah.
not be an expert in the protocols for acupuncture,
Also, they have both license.
unless they have
Does
their dual
say-
license.
Yeah, so that's why I was curious.
So it does say on like about 1, 2, 3, 4, 5 lines up on the second paragraph. Or maybe 6, if respondent is unable to secure a supervisor in his or her field of practice due to the unavailability of licensed acupuncturists in the area, then the board or designee may consider permitting respondent to secure a supervisor not in the respondent's field of practice.
Okay. All right. Good.
Yeah. So as you go on to page 19, these are all the standard terms and conditions that would be included in all probationary orders. So a lot of them are already existing from 1996, what we currently use in probation orders.
Just in terms of organization, I know this goes back to 1996. Is there a reason why we wouldn't have the standard terms and conditions come before the optional ones?
So that was something that Salwa had raised too. And we could change that up, but in the 1996 guidelines, there was existing direction to administrative law judges to actually put special or the optional terms first in an order, followed by the standard terms. So that's why we kept it in the same order. Having worked here the past years, I'm used to seeing, and I prefer seeing the special terms first, because then you know what differs from order to order up front. But you can change it. It's just, yeah. I mean, but it also makes sense. Yeah, if they're going to be in every order, then have those first. But that's why we didn't change it, Sala.
I recommend having the standard conditions first. I think it adds clarity to have them first, so that you can, for people who aren't as familiar
Right.
with all of the standards and conditions. I understand that, the team sees them all the time.
Yeah.
So, it's very familiar. But for people who don't see them all the time, it's kind of nice to see, okay, what's going to apply to everyone.
Mm-hmm.
And then once you have the optional conditions, like, for example, you don't have to go through the optional conditions and say to yourself, oh, well, what are the standard conditions? Is this repetitive? Is it necessary? You kind of know what's going to apply, and then you can pick and choose, okay, I think we need, if that makes sense. I just think format-wise, it makes sense, standard conditions. I think keeping it in this order based on a very old ALJ opinion in 1996 might be a little outdated. From what I've seen, a lot of guidelines have the standard conditions first.
Okay.
And I think later on in the disciplinary guidelines, when it sets out kind of the penalty, penalty guidelines or penalty recommendations, it also indicates the standard terms and conditions first. And so there is a little bit of inconsistency there as well.
Oh, did it? Okay.
So.
Okay.
Makes sense to me. And it would have, because I think having the standard first actually would answer some of the questions that I have of the optional ones. Like, why did we delete, why did we delete the fact that if you don't do your community service, then we can revoke probation? Well, because we already have a standard condition is violation of probation. We can do that, So, I mean, I think practically I think it's right to have the standard ones first.
Okay.
Are the rest of the board members okay with that?
Yes.
Okay. So then we will also need to, take that note to the ALJ. I think that's on page 5. No, it's not on page 5. I don't know where that was. Oh, page 7, at the very bottom. To enhance the clarity of a proposed decision, the board requests that all optional conditions that are being imposed be listed first in sequence, followed immediately. So we'll have to change that.
And would we need to change also on page 4? The terms and conditions of probation are divided into 3 general categories. Start with standard, then move to optional, then go to special.
And we'll change the table of contents as well.
Yeah.
Yeah.
So
There's quite a few changes, yeah. Okay.
it'll be a global change.
Board members, are these changes okay?
Yes.
Yes.
Okay.
Okay. So the first standard term is obey all laws. And for some reason, when we first brought it last year, we had just left it, I think it was all shall obey all laws. We added it back in to be more specific, calling out federal, state, and local. And then we added in the court-ordered, they have to be in compliance with any court-ordered criminal probation terms, payments, and other orders upon legal advice. And then it was also added in version 2, this condition applies to any jurisdiction with authority over the respondent, whether inside or outside California. They have to always be obeying all laws. Quarterly reports, just a little bit of cleanup there.
Can I go back to item 16 just for clarification?
Yeah.
Only because we've identified federal, state, and local laws, but then the last sentence says inside or outside California, which could mean internationally. Well, do we need
I think,
specificity there?
no, I think that
Yeah.
that is a valid point, and I don't see any issue with that.
Okay, just we don't have to then specify an additional layer of laws in the first sentence. State, local works for that.
For which section?
16, the new 16, so the first sentence. We're identifying inside or outside California, which could mean globally, but in the first sentence, we're just saying federal, state, and local.
Well, I see what you're saying, okay. So I think just reading it as a whole, holistically, I don't foresee any confusion there. I guess you could say inside or outside California, but inside the United States. But I think indicating federal, state, or local laws and inside or outside California just kind of implies you're talking about the states, the country.
Thank you. Sorry, Christine.
That's fine. So yeah, the quarterly reports, this is something they have to do ongoing. We do have forms that they submit on a quarterly basis. We just added if the report's not submitted, if the final report's not submitted timely, then we can automatically extend the probation. 18, this was a good change, Salwa. It used to read surveillance program, which was scary for our probationers. They thought that they were going to be under surveillance. So yeah, we've changed it to monitoring program. And let's see, it was also added that they respondent during the time that they're on probation shall not have any contact with witnesses, as in addition to the victims and complainants associated with the case. And that they shouldn't have contact with persons who previously rendered expert opinions on behalf of the board during the disciplinary proceeding, unless they've obtained prior approval. 19, interview with the board or its designee. It was added that we can request interviews with or without prior notice. Just some minor changes on 20 for changes of employment, specifying that it actually be their employment address that they notify a change about. 21, tolling for out-of-state practice or residence. We do have probationers that travel out of state or out of country from time to time, and it was always problematic because we didn't actually identify when would it constitute an actual tolling, them living or practicing outside. So, which is why we put a vacation exceeding 30 days. We also added any order for payment of cost recovery shall remain in effect, whether or not probation is told. So they would still be required to pay any costs to the board, even when they're told. Moving on to 22, employment and supervision of trainees. This was a big one to add. Respondent shall not teach at any board-approved training program during the course of this probation. There's existing regulations that prohibit probationers from teaching continuing education courses, but not teaching at schools or board-approved training programs. So we wanted to address that gap there. 23, cost recovery. We just expanded on the language. allowing them to pay in a
So
payment
this one-
plan. Yeah.
Sorry, on the
22.
22, that means they can do teaching for the CEU.
No, so in regulation, we do have it prohibited that they cannot teach CE courses. But we don't have anything in regulation stating that an instructor at a board approved training program cannot be a probationer. So that's why we added it here in the term and condition of the disciplinary guidelines, that if they're teaching at a training program, they're no longer able to do that. They're on probation.
That means, like, if there's a CE provider, they are not a board-approved training program, or we consider CE course as a board training program approved.
We don't, but if you want to specify in the actual term that a CE instructor, or a probationer can also not be a CE instructor, we can do that. I just wanted to point out that it's already prohibited in regulation.
That clarity wouldn't hurt, especially directly communicating that to the probationer as opposed to having the staff have to look that up. Because we always do a license check on the instructor, but the clarity here I think won't hurt.
No, yeah, it wouldn't hurt at all. Not teach any board.
Would you like us to add that,
Yes, I think that.
board members?
Yes.
Can I revisit 21? We're adding to vacation exceeding 30 days. Do we have any guidelines for how many times they can request vacation in a year or in a probationary period?
No.
So they could be going for like 3 weeks and 6 days, then come back, and then 3 weeks and 6 days again?
Yeah, potentially they could do that. Yeah. If it gets in the way of them meeting their terms and conditions and satisfying those, then obviously that would come out as a violation of probation. But if they're able to do that and still meet all their terms, then.
So I think sometimes, I guess, let me give an example. So if they're required to do weekly fluid testing, they would be, by that term, prevented from taking these vacations in order to satisfy that term, or else they'd be violation of that requirement.
Right.
So in some ways, the probation terms and conditions will be limiting on their ability to travel.
Yeah, some of them. Definitely if they have biological fluid testing, to be taking such frequent trips like that, for sure. I don't know of any others that would really necessarily prevent it.
So I'm thinking of, for example, if they have to take coursework within a certain period of time, or they have to take evaluations within, 30, 90 days, regardless of their vacations, if they're not satisfying those terms.
Right.
I would think also that would interfere.
It would be addressed, during those terms. Those would come into play, yeah.
Just to confirm, for 22, we'll be adding the language for CE providers as well.
Do we want to say provider or instructor?
Sorry, instructors, board? Yep, instructors.
Yes, instructor.
Does the president want to allow it?
Yeah. Sure.
So Jacques here, Empress College, on the probation, let's say this particular individual is on probation, and the 30 days, they might decide to do 45 days medical mission work, let's say in Nepal, as long as, whatever the probation is, of course, those are very important. But let's say that they are really going out of the country, not on vacation, but on medical mission work, and it's documented. What would you say about that?
That's a good point. It's actually making me think we should use a different word for vacation.
Okay, thank you.
But yeah, it's more the length of time, because if they're going to be out of state for that length of time, they're not able to comply with their terms and conditions. So that was a good point to raise. could be other reasons other than vacation that they'd be gone for a length of time. So do we want to change the word vacation?
Just to reside exceeding 30 days.
Would leave California to reside?
For
Exceeding-
practice outside of the state for greater than 30 days.
Maybe just to leave, should leave California exceeding 30 days, not even specifying what they're doing.
Leave California would be better.
In the event respondent should leave California exceeding 30 days.
Okay, so then we'd also remove the or to practice outside the state.
Wait.
So now it reads, in the event respondent should leave California exceeding 30 days, respondent must notify the board or its designee immediately in writing of the dates of departure and return. This is okay? But then we say periods of residency or practice. That's like, we may need to change the second line. This period outside of California will not apply to the reduction, or is that too vague? The last line of 21 of the first paragraph.
Or just periods of residency or practice. Oh, because we're removing practice.
Yeah.
Uh-huh. Periods of residency exceeding outside of California exceeding 30 days will not apply.
This
Not
period.
seeing it. Where are we?
20.
It's 20.
I'm on 20, so I'm
Condition
determined
number 21.
21, yes.
The last sentence of the first paragraph.
Any order for payment, that sentence? Oh, last sentence of first paragraph?
Periods
Yeah.
of residency.
Oh, periods of residency or practice.
So we took the residency and practice out earlier. So then how do we address that in that last?
Periods exceeding 30 days outside of California
Oh, that works.
will not apply. Reduction of probation. Yeah.
Exceed.
Board members, are we okay with that change?
You said will not apply?
Will not apply towards their probation. Yep.
Just going to specify over 30 days in that last sentence. Yeah.
Periods exceeding 30 days outside California will not apply to the reduction of this probationary period.
Just grammatically, periods outside of California, I think just it doesn't, how about periods spent outside of California?
It's
Any time exceeding 30 days outside of California. Periods that you're having an issue with?
Well, we're looking at the last sentence of the first paragraph there, right? And I think the proposal was to remove residency or practice and just have it read periods outside California.
Oh, we were saying periods exceeding 30 days outside California. Outside of California? You just want to just add the word of?
Periods exceeding 30 days spent outside California.
Periods of time.
I see, yeah. There needs to be a verb or something.
I just felt like it just sounded like an incomplete
Periods
kind of
exceeding
sentence.
30 days spent, yeah. So then it would read periods exceeding 30 days spent outside California will not apply to the reduction of this probationary period.
Sounds better.
Board members are okay with that?
Yeah.
So,
Okay.
Thank you.
So I think we were on
23.
23 for cost recovery. We do add that cost recovery will not be told. So if they're spending those over 30 days outside of California, they still have to pay their costs to the board. Weren't any version 2 changes in that. So 24, violation of probation. There was just a
an error there that was corrected in version 2, but other than that, this is just basically saying that, yeah, if there's any violation of probation, then we can file a petition to revoke, and then they can have a hearing on that. And then we have continuing jurisdiction over respondent during the time that the hearing is occurring and the probation of violation, excuse me, the petition to revoke is being heard. $25 probation monitoring costs. This was what was a special term that, or optional term that we made into a standard term. And basically during the course of probation, they would be required to pay to the board costs on an annual basis, cover the costs of probation monitoring. 26, license surrender. This just allows a probationer to voluntarily surrender their license. It's deemed as a disciplinary action, but it's basically a way for them to opt out of their, not opt out of the probation, but for them to end their probation if they can no longer comply, but it is a form of discipline. Currently, we don't have an option like this. If they just don't want to comply with their probation, they have to basically violate their probation in order for us to file a petition to revoke. We did in version 2 take out the, this was confusing when our Attorney General was reviewing it. We did take out this line, respondent may not petition the board for reinstatement of the surrendered license. I think it was confusing because
We issue new licenses. We issue the same license number. We generally reissue a new license. I think that's why.
no, that's not why. No. It was because further on we say if respondent reapplies for an acupuncture license, the application shall be treated as a petition for reinstatement of a revoked or surrendered license. Yet earlier we said that they are not allowed to petition for reinstatement. So it was sort of contradictory. So we fixed that.
So ultimately, this will also reduce the amount of time with the ALJ. The board could just accept the surrender and not have to go that route, not have to do the petition and the hearing.
Yeah. Well, there wouldn't be a hearing on it. It would be pretty excelled. They want to surrender it. We would do a stipulated settlement, voluntary surrender, and it's done. Yeah.
Right.
And actually, the executive officer has authority to sign stipulated surrenders. So that is fast-tracked. Severability clause, again, a new term that we didn't have before, just saying that each condition of probation is separate and distinct, and it doesn't deem the whole order unenforceable if one of the term or conditions is not in effect. 28, notification of name, address, telephone number, or email address changes. Again, this is just kind of a new way of us capturing all of the current changes and contact information from a probationer. 29, maintenance of a clear and active license. We don't want our probationers letting their license just lapse and being allowed to in their probation by just, canceling out or something like that. They have to maintain an active and clear license. And then there weren't any further changes to the actual terms and conditions there.
So something I think I commented on and would recommend for consideration is the addition of terms and conditions that relate to notice to patients, to employees, to employers. I see some of that embedded in some of the terms and conditions, but I think separating them out as their own individual terms and conditions would be useful.
An additional section on notifications Or separate sections for notification of patients, notification of employer.
Separate for each, because I could see, I mean, and leave it up to discussion, consideration, and of course, those who work with these very often, but I would think that there's some situations where you might want notification to certain individuals, but not others. For example, you know, you might want to notify the employer, but not think it's serious enough to notify every patient, or you want to notify certain patient populations, or, well, maybe not separate patient populations, but, or, you know.
Oh, okay.
Or if you're an owner of a business, you might want to notify your employees.
So how would you you're saying one term that addresses what a certain population would be notified?
For example, a term, an idea or a suggestion is perhaps to consider a term that says, you know, notification to employer. That would be one term, draft language for that.
Okay.
Another term might be notification to patients. Another term might be notification to employees.
Okay, I see what you're saying. Yeah, we had.
Thing
Okay,
that's
I see what you're saying.
separate item, like a notification, right?
Just simply being on probation, that notification to those individuals?
Yes,
Okay.
notification of the probation, as well as maybe the, you know, and it's something for, of course, requires some development in language-wise, but perhaps also the accusation or the discipline and the underlying situation. You know, there could be a variety of items that
Okay.
might want to notify patients so that, for example, they can make an informed decision.
Right. Are you viewing this as a standard condition or optional?
I think that's something that
Oh.
should be discussed.
Okay, okay.
Research that.
Sounds like these would be more optional, as even with that bill we discussed today, which we have a watch position on. As in, right now, there isn't a case where we would need to have the probationer declare this every time. But the board can discuss where they would like to place it. It seems like there would be 2, possibly 3, notification to employer, notification to employees, and notification to patients. I wouldn't imagine that you'd need to notify every single one of those in every single probation.
And just kind of looking through the terms and conditions, I apologize if I'm missing it, but like restrictions on supervision, if there are any.
That's an optional.
Yeah, and the optional. Restrictions
Number 7.
on, yeah, number 6 and number 7. Restrictions on patient population or practice setting. And number 7, restrictions on practice techniques and modalities on pages 12 and 13.
That include restriction on, for example, ability to supervise a trainee or a student, or
We have that as a standard term. Where is that?
Number 22.
22 on page 20, employment and supervision of trainees. They're not allowed to have any supervision over acupuncture trainees or employ them.
I might recommend language for clarity in the title to say restriction. Like restriction dash, for example.
This would be on page 20, board members.
Or restriction on, that would kind of mirror number 7.
Maybe then employing as employment, because employment might be confusing there. And personal employment as opposed to employing.
Yeah.
Board members, are you okay with changing 22 with the restrictions on employing and supervising of trainees?
That's more clear, yes.
Yep.
And this would be a standard term.
In terms of the term that was just discussed by
Sawa?
Ms. Bojack. Yeah. I mean, to me, I think it's worth having that discussion. I mean, it kind of wraps in with what we were asking about earlier about the watch, and I think Mr. Osorio's question as well, right? Which is why wouldn't we want to support this bill? And I think what we heard in response was, at this point, staff thinks it might be too punitive or over the line potentially to require, you know, a probationer to have to notify their
Every
clients and
single-
customers. And so can we do, I mean, this is obviously coming back to the board, so, and I would like to have that discussion. I don't know if we're going to have it today because I'm not sure if the staff has come with, I'd like to hear a little bit more why we're watching the bill and why we necessarily wouldn't want an optional term. That is, you are notifying, as part of your probation, you notify your patients. We obviously historically haven't done that. I don't know why. You know, there's probably a good reason. So we can either make the change today, but I feel like we just did something earlier in the meeting that's sort of counter to that, right?
Yeah.
So can we, when we bring this back, have some proposed language to consider as an optional term? To me, I mean, I think it is something to consider.
Yeah.
I'm sure you agree since you.
100%.
Yeah, I think obviously, yeah, it would definitely achieve consumer safety. I think the other concern is, yeah, it would drive these probationers possibly out of business is a concern too. But obviously, consumer safety is number one. So I think definitely we can bring back some language and maybe we can identify different populations
Yeah, the
and
employer
different
versus
options.
the patient versus, yeah, exactly.
Right.
And
Yeah.
you know, for me, the proposed language would probably make sense in optional terms and conditions, but I don't know if we need to necessarily make that decision now, but I think it is something we should discuss.
Are you also suggesting that we move number 22 to optional? Or that's just part of the discussion?
No. I think that's fine in the
Okay.
standard, where it is. You know, I think it's fine there.
Correct me if I'm wrong, did we also not include the CE instructor in section 22?
We are adding it now.
Adding it, so we
Yeah.
would just need to amend the title to also be clear about the CE instruction?
Right.
Or instructing continuing education?
On-
Board members, is that okay?
Yes.
Yep.
Restriction on employing, teaching, and supervision of, I don't, yeah,
It's
we'll have
better.
to change it.
Yeah, add that, yeah.
Instructing, supervising.
Teaching.
Also for consideration, regarding restrictions, which might fall under optional terms and conditions, the idea of possibly having a term and condition regarding solo practice, restriction of solo practice.
So we kind of we thought about that. We thought maybe that was covered under the restriction practice, the practice setting one. I think it was 6. So we could say there, excuse me, let's see, respondents practice are restricted to no solo practice. It kind of leaves it a little open-ended where what we can plug in there.
I guess, and I'd leave it to the board to consider whether or not they'd whether the board would want more clarity in the guidelines to, specify certain, specify solo practice or leave it more general that way.
I think solo practice is included. Just try to think the ownership, right? The independent practitioner, they are the owner for the practice, and they are the employer themselves.
I think that does bring up a good point, Salwa, because We have used no solo practice on some things before, and it spells out what is considered no solo practice. Otherwise, this leaves it open for us to kind of come up with that definition, staff level or something. So that is a good point. It was, I think, in some iteration and got taken out along the way. Yeah, because there's not really any definition of that.
The members like us to look at the solo practice aspect and bring back at the next meeting some language in?
Yeah, I think that makes sense. And I think it probably makes sense to fall under this provision 6, or 6 and or 7. But yeah, I think it probably makes sense to think about spelling it out within there.
I know that there was a question before about 90 days, whether 90 days was too long of a, I think maybe that appeared in the uniform standards. I'm hoping someone can jog my memory, but there was a comment bubble that indicated whether 90 days was too long a period, and we don't have them here now, so that's why I'm
Long a period.
like the probationer was required to do something within 90 days, and there was a comment, perhaps that's too long. Was that the uniform standards? Was that the CE?
I can't
CDE?
remember, but
It was the uniform standards.
this is all your edits if you want to look.
I have
okay.
them, yeah,
I
Would
don't.
it be within 90 days if they had to do the
Eval.
no, I thought it was the 10. That's 30 days. No.
I think it might be the CDE. I think I might be referring to the uniform
I don't
standards.
see
Oh,
Yeah.
there's a psychological evaluation that they have to do that within 90 days.
It's 90 days here, yes.
But that's understandable, seeing as how they have to find someone, we
Yeah,
have
that
to review
takes
them,
a long
approve them.
time.
Is that
Actually,
in-
that's in physical
Also the
examination.
practice monitor too, 90 days.
And the practice monitor.
Standards, so it's under.
So are we
few
looking
places.
It's in
at
a lot of different places.
Yeah, it's mentioned in a lot of different places.
number 2? Okay, let me check.
Exam, and then, yeah, so all this is in 90 days.
Although we do differentiate Section 6 and Section 7, 6 being restrictions on patient population / setting, practice setting, and 7 being practice techniques or modalities restrictions. 6 is 60 days, whereas 7 is 30 days with that plan. So that doesn't seem consistent on those kinds of restrictions, unless the board feels that those are different enough to warrant that difference of time. There's, go ahead.
You're talking about the difference, 60 days in 6 and 30 days in 7. Is that what you were talking about? Yeah, I think the idea that somebody would have to completely change their practice setting, like let's say if they were in solo practice, then suddenly now have to be in a group setting, it would take a longer amount of time to fit those and satisfy those terms, whereas their practice techniques, they're just dropping, doing certain techniques. It might not take as long.
So where's there direction then that we can, for those 90 days, did we address your question in ways?
Yeah, I think
Okay.
it was, I apologize, I think it was in the uniform standards that
Okay.
I've seen it.
We're at section 27 now,
Oh,
severability clause.
I thought
I think I'd
at
gone through all those.
30 with the,
We went through 30? Okay.
We're
The
at page
30.
23 now, right?
Penalty
Page
guidelines.
23, yeah, the penalty guidelines.
All right.
And just, can I ask a question, just in going through the next,
Yeah.
Almost 20 pages? If it's a single underline, and this is going back to what Mark went over, single underline, single strikeout, that means that the board had already approved those back in 17, right? So maybe for the sake of efficiency going forward, maybe we should just specifically focus on the page, and and the double strike through slash, double underline.
Okay.
You know, because again, if this board previously, and then we can make other comment, and the chair can say, stop talking about this, but,
That's a very good suggestion.
and we can also make other other suggestions, but maybe just for the sake of efficiency going forward, maybe just the double underline, the double strike throughs.
Yeah, sure.
But I guess that brings up the point if we're giving direction, like for staff to come back about the, the notification to the patients or the employers and some of the other things, is that going to be now like a triple underline? Because we still haven't, because I'm asking because we as a board have not actually approved that or said, we want to discuss it, so.
That was a little bit of a back and forth we had. I mean, technically speaking, we haven't noticed any of this to the public. And if we had, technically we would need to do that, but in discussion with OAL, they said, well, you can do it either way, but it's sometimes more helpful to do the single double underline, but there is no direct requirement that we do it that way. So in theory, we could just come back in August with all of the changes made, no double underline, no single, or none of that stuff, and the changes that the board directed us to make today would be single underlined. Does that make sense? So we can do it that way. It's almost a style thing in some ways, but.
I asked that just because I don't actually want to then rush through the single underline, because if the single underline, single strike through were actually things like we just talked about, where we didn't actually agree on it, but that's why I'm asking, just to clarify that. I thought this was helpful to have the single underline, the double underline, but.
Well, we can always do italicized.
Yeah, I guess I'm asking just more so because I don't want us to discount the relevance and the significance of the single underline if in 2017, if the board actually didn't approve those changes,
Yeah, well, the board
they
did
did.
approve
Okay,
all the
so
other
they did
changes.
approve.
So.
Okay.
Yeah, we just thought it a benefit for the new members like yourself and Ruben
No,
just
I think
to
it's very
sort of
helpful.
review them again.
No, I think it's
But
very helpful.
we can skim, like you had
I
mentioned.
think a recommendation for, future versions that go before the board is to kind of, once the board's out, an opportunity, see, okay, what did the, previous makeup of the board look at and approve? What is this board looking at now that's new? Okay, the double underline's helpful, but for future versions, converting everything to single underline. And then for things that are added, like let's say notification of patients, maybe like a comment bubble that would
Highlighted.
or a highlight that would draw attention to it without gradually increasing the number of underlines that we have. Can get a little bit confusing.
We'll play
And also the single underline and double underline have meanings within the rulemaking process that it has been through the 45-day or 15-day comment periods, and there were additional changes. So I think just having the double underline at this point, when this is a brand new rulemaking package, just is a little bit confusing.
So then moving forward, are the board members okay moving to a single underline for the next iteration of this document?
Yeah, if we have a
And then
general
highlighting.
if we have a general person's agreement that we're not going to relitigate every underline, you know what I mean? Like I hope that for all of our lives we do not go through all of this again. But yeah, yeah, no, I agree.
Do so.
Okay.
Um,
Going forward, you just want to kind of highlight just the version 2 double underline changes in interest of time
right
since
now?
they were already.
Yeah, I'm okay doing it that way. I mean,
Okay.
but
You guys
Okay.
board members? Okay. Right, let's do it.
So I'm not going to highlight on page 23. There's some things where we just cleaned it up. It didn't change anything no substantive changes. So, and going forward, let's see, page 27.
Yes.
And this is the section where we identify all of the different violation codes, and if they were to violate that code, what the penalty guidelines would be.
Are we starting with 24, page 24?
27 now.
No,
Oh,
page 27.
27, yeah. So there were no double underlines or anything. So, yeah, just clean up for section 4955A and changing the edition of the uniform standards that it's citing to, and a statement, the probation terms contained in the uniform standards related to substance abusing licensees shall replace optional conditions 10, 11, and 12, which kind of relates back to the note that we put on those conditions that these uniform standards would be used in lieu of those terms and conditions 10, 11, and 12.
Yeah, I guess that numbering will be different now, right? Because the optional now goes second, so it's going to be like optional conditions 22.
Yeah.
So maybe just note that. That we're gonna have to-
Good note.
I noticed that none of the penalty, well, going back a little bit, I'd recommend that these be called penalty, like recommendations, not guidelines, because it's just confusing with the disciplinary guidelines versus penalty guidelines.
Oh, yeah, to address, I think, are you going to bring up the different sections we didn't put in?
It does say recommended action. So you're talking about page 23, penalty guidelines, changing that to penalty suggestions?
Penalty recommendations.
Recommendations, yeah.
Board members, are you okay with that?
Yes.
Okay.
And then for each of the recommendations, it doesn't indicate citations, the possibility to issue citations, minimum and maximums. So I was just throwing it out there for board consideration.
So, yeah, we didn't have a chance to actually ask you about the comments you made, but we have in our regulation, we have minimum and maximum for our citation fines. But I didn't know if you meant like by a certain violation, because can we put that in here when these are disciplinary action guidelines? Because citations are not disciplinary actions. So would that make sense to put in citation and fine guidelines within a disciplinary action?
I think as
Guidelines
a
document?
I think as part of discipline, you can issue the board's choice to issue a citation. So I don't see any issue with that.
Okay. Okay.
Wait, but you just said that citations are not discipline.
No, they're not a disciplinary action. They're not.
It's
seen as-
a term and condition of probation.
I've just never seen that, so maybe I've never seen that.
We don't cite and find
No.
probationers unless it's a separate incident of a different
Yeah.
action, right? So maybe we can look into it then?
Yeah.
Let's
Look
look
into
into
it.
it. Board members?
I'm
Okay.
confused on that.
I have seen it used, but
Okay.
I think it's something that we could talk about more.
Okay.
Over here, right?
Okay.
Maybe on the 40 there's a change.
So also when, Saul, when you reviewed this, there's different general business and profession code sections. When we did in a prior iteration have like a exhaustive list of all of the ones that would apply to licensed acupuncturists, and they kind of got weeded out because they could all be classified under our act under general unprofessional conduct, and which would then be addressed here when you get into the actual Acupuncture Licensure Act. That's why, but as an alternative, the board wants to see each general provision called out, that it does apply to licensed acupuncturists. We can put that back in to be reviewed.
I think one that I've tended to see where guidance would have been nice is 480 situations, applicants, and 490. You tend to see those fairly often, and having guidance on them is helpful.
Okay.
This would be something new to include? Okay. So it's not on any page in this document.
So the reference was to Business and Professions Code Section 480, which governs the denial of a license to applicants. And while the disciplinary guidelines are usually geared towards licensees, we as council, the board, ALJs, and DAGs see situations where an applicant is being denied their license. It's going through the hearing process. Perhaps there's a stip. And, you know, the board and council are called upon to review the stip to determine whether or not, you know, the terms are appropriate. And that's where we tend to not have guidance. It's also 490 for criminal convictions, having guidance on that one. That one governs. I'd have to pull it up, but can you recall it governs criminal convictions, I believe, for licensees.
Oh, for applicants.
I think 480 is for applicants. I think 490 relates to licensees. Let me pull it up.
I thought they both.
So this is to be added to currently page 24, recommended action by violation of general California Business and Profession Code provisions. Okay.
Yeah.
So that our board members and audience at home
So
can be on the same
490 is a
page.
general provision.
490 has to do with suspension and revocation of licenses.
On the ground that the licensee has been convicted of a crime, if the crime is substantially related to the qualifications, functions, or duties. I think, and correct me if I'm wrong, I think 480, 490 tend to turn up fairly often.
So we never cite 490 because we have 4955B, which is conviction of a crime substantially related to the qualifications, functions, or duties. We'll use that from our act. 490 we use, the reason why I thought it applied to applicants because I have seen it in our statement of issues. I think they bring it up for 480 and 490 in both of those possibly.
480, I think maybe 480.5.
Maybe that's it, yeah. But for 490, would we need to add that in if we already have penalty recommendations on page 27 under 4955B of our act?
Which section is it?
4955B, page 27 at the bottom.
I'd have to do a little bit of a comparison, but it's something I can look into.
Okay.
So the board members are okay with us looking into adding more general provisions if they fit the bill?
As a matter of fact, I have a question regarding the unprofessional conduct. Is there anything that we can add regarding the treatment of minors? Is there something that we can add, a provision that the parents and the provider must discuss what is going to be, whatever the treatment might be, and that the parents or both have discussed this and have a written
agreement?
Right, agreement that it has been discussed and to be kept in record.
I think that would kind of fall under the, you know, what we talked about earlier, adding a potential provision regarding notification of patients, because if you're going to treat a minor, usually you have to notify their guardian, so it's just as a matter of law, outside of the terms and conditions.
I didn't see this in the I know that if a doctor is going to treat my daughter, and they usually, you know, is discussed beforehand. Just to prevent any kind of issues, I would like to see if there's anything that we can do regarding that. Highlight it.
But this would be applying to general practice, not to disciplinary guidelines.
Well, yeah, I guess, yeah.
Okay, so we can look into that as well.
Yes.
Yeah.
Yeah, because there's nothing specific in our act on that, but you're saying that it's a general law that you would have to, that all practitioners,
I thought what I was hearing was kind of a term and condition regarding notification of parents regarding the discipline. Is that?
No. The treatment for a minor, that the minor would not be going by themselves to be treated or to be aware of what is going to be, what to expect of any kind of treatment, prevent any kind of
Prevention, so
And I
a
think-
condition
so
that
I-
would prevent the treatment of a minor?
It's almost like a law.
I
that he's
think
talking about.
Ben had a correct assessment that this sounds like it's a recommendation outside of the disciplinary guidelines.
Right.
Which we can look into, and we'll source what governs the treatment of minors, and there may be some general code. If there's, parents not aware of this for acupuncture treatments, then we can put that out there. And then for the disciplinary guidelines, that could easily be incorporated into the restriction of patients.
Okay.
The next double underline would be
At page 28.
28.
Global change.
Okay, it was a global change to add the special condition that relates to the uniform standards. Oh, that's right, it's not a global change, but on 4955A and 4955B, those both can relate to substance or convictions or substance use. So that's why those two were added there, those notes. I don't think there were any other double underlines within the recommended penalty or
And those will be
penalty
renumbered.
recommendations.
Right.
What?
Once we do the renumbering of standard first, then optional, then special,
Yeah.
that
those all
language will be
change.
updated in both sections.
I noticed that Business and Professions Code sections 4935 and 4936 weren't included.
Okay, so 4935 is a criminal misdemeanor, so I don't believe we would ever take disciplinary action on, because it's unlicensed practice on a licensee, citing that unless I've never seen it because it's a misdemeanor. It's not an administrative violation, but 4936, use of the title doctor, we cited it back to just 4955. If it was like false or misleading advertising, it could fall under that using the title doctor. Or we could have it, spelled, we could actually have it standalone. I don't know if we haven't in the past, if somebody's sole violation was that they were using the title doctor, unless it was super egregious, which we've never come across. We haven't dealt with it through formal disciplinary action. So I think that's why in the past we didn't put it in the guidelines. But if the board wants to see specific penalty recommendations for if somebody were to use the title doctor, if they didn't have, a degree or a certificate license that authorized that use, we could put that in here in the guidelines.
I think that's a good idea.
Okay.
Rest of the board members? Open to that consideration?
It's fine.
That's good.
Again, this wouldn't usually be just a standalone cause for discipline, but definitely included as a cause for discipline.
Yeah, definitely. And I guess, we can come up with some penalty recommendations for your guys' review for next time.
This is a conclusion. Public comment, please.
Afternoon. So, and this topic remind me, I have a colleague friend, and she showed me, she printed a book when she practiced in China. She's an MD in China. She also a licensed acupuncture here. But she has problem because she gave the patient book she brought from China for educational purpose. Then she told me she get into the trouble because she cannot give the patient the book she wrote and printed in China with the title MD. Even he's a licensed acupuncture here. I think we have to make it clarify. Number one, the practitioner did not make any false statement. The book was printed in China. When he was practicing in China, He's MD in China. He used that book for educational purpose to his patient, her patient. What's wrong with that? Okay, I think we need to make it clarify. The misleading is we don't want people, biased people. He's not qualified for that title. And I want to make in more detail for the misleading false advertising to distinguish the fact and bias. That's my comment.
Thank you.
Do a follow-up here. Quick follow-up. Thank you for that very important clarification, which brings us to this thing as far as advertising, what you mentioned. Right now, in this profession, there's DAOM, there's the DDC, there's the old OMD. It's a big confusion, and the public needs to know the qualification. In the state of Colorado, they have to have a disclosure on their website, what type of doctorate and what is the requirement. We know that there is this new online transitional 200-hour doctorate, which is a WASC-approved school that confers this degree. And yet, you know, the consumer doesn't know if it's the 200-hour or is it the 1,200-hour extra that the DOM has, or whatever other degree. So I think there has to be a proper disclosure on this doctor title to clarify the field and see what is the training and what type of doctor they are. So I hope that the board will look into that, and actually I will ask the board to put that as a future agenda item too.
So for efficiency purposes, I'd recommend reserving public comment until after review of the disciplinary guidelines. And I think what we're considering right now is just the disciplinary guidelines for existing regulations. I think maybe some of the comments we heard are proposed future regulations or changes to the law, and I think that is, you know, appropriate under maybe future agenda items category.
I'm going to jump ahead and go to page 32, where you can see the next double underline. It was just recommended that for statement of issues that we cite it back to Business and Professions Code Section 480 when an applicant is denied a license. We file a statement of issues, and it relates back to that section there. And then I guess it goes all the way to page 39. Under proposed decisions. And again, at the bottom, this section, when someone fails to appear for a scheduled hearing or does not submit a notice of defense, it results in a default decision under Government Code Section 11520, just to cite it back to the Government Code section that drives that. And we did that as well on page 41 when we talk about in a penalty relief hearing, when someone doesn't appear for their hearing, then again it result in a default decision under that code section. Oh, and I missed one on page 40. The first part of that page, it was rewritten. The board will not relitigate the facts of the original disciplinary case in determining whether or not to grant reinstatement if somebody shows up for a penalty relief hearing, such as yesterday. They should not talk about the facts of or try to relitigate, the prior case that put them on probation or on a revocation. That was all that we added.
Thank you.
So I guess my only comment on this last point is I think that's important, right? Not to retry the original case, but then, you know, it's a little confusion to say, you know, the board will not relitigate the facts, because in reality, yesterday we went through the original facts a lot. And you kind of have to sometimes to get to credibility determinations and whether or not the person is rehabilitated. So I don't have a problem with the way that this is written, but I think it's hopefully future boards, don't become hesitant to ask questions about the original case because, I think the DAG will probably be asking questions, and I agree. I mean, it shouldn't just turn into a rehearing on the original revocation or probation or whatever. But I mean, I think the reality is you're going to have to get into those facts, a little bit.
Yeah.
So
It's a good point to make, to be concerned about future boards. Don't want them to not,
I don't
ask
want
questions.
them to. I don't want them to think that they can't ask a question.
Yeah.
Like
right.
the original facts are off limits.
Right.
But
Is there a more precise word we can use there
No,
as opposed to relitigate?
well, no,
Or
it's actually not
retry?
even. I like relitigate. That's good. It's the will not. Maybe it's almost like a shall or will not, might,
May not.
May not.
may not. Well, I don't know.
I
Should
would
not.
actually, I agree, and I think just from a standpoint of not limiting what the board can do in that way, phrasing it, the board is not interested in relitigating.
Right. Maybe
just-
yeah.
Yeah.
I like that. It's just,
Oh,
which is the point is, look, we're not interested in relitigating, but saying, the board will not, relitigate facts,
More firm or,
I just like the
closed,
is not interested, which I noticed now was the original language.
Yeah,
That's,
we'll restore that original, the board is not interested in
In relitigating?
In relitigating.
right.
Okay, so we'll make slides. Rest of our board members okay with that?
Yeah, that's better. I agree.
Okay.
And I think the way this new language, it kind of narrows it to reinstatements as opposed to probation cases. So I would say, unless there was a particular reason for that, I don't see why we'd want to, the board would want to limit it that way.
I think this was something our Attorney General's office had recommended, but we didn't have, comments back and forth, so whatever the board chooses to do,
So that new wording is okay? Board is not
Well,
interested in relitigating.
To Ms.
the fact?
Bojak's point, I think that's a good point, right? I mean, we might not want to limit it just to reinstatements, right? Because it's going to
right,
be.
at the end, it says grant reinstatement,
Right.
I see, not to grant
You might want to just say, in determining the relief requested, right? Or in determining whether or not to grant the relief requested, rather than reinstatement. Or sometimes it's going to be a probationer that just wants probation dropped.
But wouldn't we have to say both reinstatement or relief? Or we can consider reinstatement as
I guess the relief requested would sometimes include reinstatement, or, yeah, I would think.
relief from not being
So,
in practice.
And correct me if I'm missing anything, but I think the two scenarios that this might apply to is the reinstatement or early termination of probation or modification of penalty. Would there be any other circumstance?
No, I don't believe so, not
So
my,
perhaps clarifying to grant reinstatement or early termination or probation and modification of penalty. Yeah, so it's a bit of a mouthful,
Right.
but.
It's clear.
okay.
Board members, spelling it out like that, would that be okay?
Yes. Yes.
So noted. That does bring us to the end of the document in terms of reviewing the double underlines and the double strike throughs. Were there any additional questions or comments from the board? We will go ahead and include those changes, and we'll bring them back to you at the August meeting with a single underline to denote all the changes and a single strike through for all the omissions, or deletions, I should say. Public comment.
I just had one quick comment about your section on billing monitors. It seemed to me that you guys were leaning toward having a licensed acupuncturist as a billing monitor, and there are more qualified billing monitors than licensed acupuncturists in many cases. So my biller, for example, has 3 billing certifications that are national standards. Is that something that you use, or is that available in these disciplinary guidelines as a billing monitor to use someone who specializes their monitoring and billing and not just acupuncture?
Board members, do you want to open that up to
I think it's a good question.
seeking additional qualifications outside of just being a licensed acupuncturist for a billing monitor?
We should just let the staff look into it.
We'll look into it.
Look into it.
Please note that.
Thank you. So,
Future agenda.
yeah, so thank you, Christine and Mark.
The board did, I think it was John asked a short time ago about covering the uniform standards. Do we still want to go do that through the brief history of that, or do we want to just wait until August when we're going to bring that back?
I'm waiting. I mean,
Okay.
Without it in front of us, it might be.
Yeah.
We would move to August meeting.
Okay.
Board member, are we okay?
Okay. Thank you.
Yeah, let's do that. So now coming to agenda item 24, which is a future agenda items. And the board members, would you like to see what's to be on the future agenda? Let's go with the board members first.
I don't have any future agenda items.
Ruben, we'll take your practice on minors question. Okay.
The future agenda, yes, okay. Now public, open to the public.
Okay, first I would like to thank all of you today. You put such a tremendous amount of effort and work, so thank you very much on behalf of Empress College and our community. My request for future agenda item is open disclosure and transparency on individual using the title doctor that are doctors according to some of the specificity of the licensure. However, as I mentioned prior in my public, in the statement, there is a big difference between the 200-hour online doctorate that is being offered right now and the 1,200-hour accredited DOM from ACOM. So I think the individuals that are doing that, they are within the right to call themselves doctor, but it is a big difference. It's 1,000 hours of additional training. So if we can have some type of disclosure on the website, as done in Colorado, they do that on their statements. Thank you very much.
Thank you.
Yoon Kim, Empress College, and I echo Dr. Morris Marcos' comment about all the hard work on the board. Thank you very much. I'd like the board to consider 2 agenda items for the future, and they both are regarding revising or updating the current curriculum standards. So first, we talked about transfer credit issues. The board curriculum requirements require that graduates take general biology and OM research to be able to sit for the boards. Now, we spoke about one of our students who has a PhD in neuroscience. She's a dean of a physical therapy program in Los Angeles. She has written 13 peer-reviewed articles. Now, we're going to have to ask her to take OM research at our institution to be able to sit for the boards. I have a doctorate in education. I have taken the research courses. I've done a dissertation. Research is research. Really, the best practices in research cut across all the disciplines. So to ask this doctor of neuroscience to come back and take the research class at Empress College is really absurd. Also, we have a student who is a biology major from UC San Diego. Now, he does not have quote-unquote general biology on his transcript, but he's a biology major, and to ask him to take general biology at Empress College when he's earned a bachelor's degree from a UC in biology is, again, doesn't make any sense. Now, no, it's not the board's intent to create scenarios like this, but the curriculum requirement, I understand, requires that, that the staff follow the letter of the law. But really, these requirements need to be reviewed and revised to make sense and to really better serve our students. So I ask that that be put on a future agenda item. The second item is the requirement for clinic supervision. Now, last year, the board invited the stakeholders to come and give input on the issue of clinic supervision of our interns, and we provided a lot of testimony. We're unanimous about asking the board to rely on ACOM standards for clinic supervision. So nothing has happened since that stakeholders meeting, and so we'd like to really see a timeline and also to have that subject put on the agenda for future meetings. Thank you.
Thank you.
One of my office assistant is studying acupuncture in one of the board-approved school, and there's a community rumor the school had problem with the board. Then my assistant asked me, will he continue to study in the school or wait for in the middle of the program if the school is closed by the board? What happened? I have no answer. And I know if there's a litigation between the board and the school, the board should not disclose any material information. But as an individual person, what should I tell them? Will the person continue registering in the school to study or transfer to other school? Or what's the result of the dispute between the board and the school, the board-approved school? So I have no answer. So if there's a investigation on the school and should the board disclose the fact, allow the student, allow the future applicant get aware before they make any decision. And so that is my recommend to the board, and I know there's something going on, but maybe a lot we should not disclose right now. Thank you.
Thank you. Any other public comments?
Thank you, everybody. Long day, and then you have fly back. So I just have a very short comments again about the continuing education, and I hope maybe next agenda you can put in next meeting put in agenda how to monitor or check out the providers. Qualification and the course, they really have the quality of course or not. So maybe right now people, I heard everybody say like as long as they apply, I don't know but the percentage to approval, but I really urge the board to check on the quality. Thank you.
Thank you. Any other public comments? Future agenda. Okay, seeing no. It's 3:53. Okay. So thank you everyone for your participation. Thank you for the staff members and for put this 2 days event together. And thanks for the board members here working hard. So the next scheduled board meeting is in August 23rd, 24th, is in San Francisco Bay Area. And the meeting is adjourned. Now it's at 3:55. 3:54. Thank you. Thank you.